chat's got soul. From the gavel to the gas, we're watching it all. Covering the courtroom, big case or small. Laugh when we can, cry when we must, but it's all real talk, you can count on us. We're not the pros, just fans who care. With popcorn in hand and a comfy chair. And every twist, we're right there. Together like we're all in the witness chair. This is the Broken Baker, where the trials come alive, where the chat is wild and the vibes survive. We're watching the worst of what people do, but we keep it light, yeah, that's our truth. It's the only place for crime, and it feels just right. We bring the justice talk into your night. So hit that stream, don't miss the call. At the Broken Baker, we cover it all. Oh yeah. We're just flaming with the view, but we ask the things the world wants to. Digging through the facts, side by side. Even when it's dark, we bring the light. No clickbait, no fake feels, just truth and the highs and the reels. With the chat that roasts and rise, we're just here for the case and the vibes. This is the Broken Baker, where the stories unfold with a smile in the heart, even when it's cold. Yeah, we cover the bad with a wink and a grin. Where the real talk starts, come on, jump in. It's the only place to be, can't you see? For trials and truth, it's BBTV. Broken Baker, where the trials come alive. Yeah, we'll be here, trial after trial. Yeah.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any you are, and we are jumping straight into it because them people lied to us. They said it'll gonna start at 10 o'clock, and they already started. Those typical Georgianers. I don't know if that's what you call them, but we are a little behind, but who doesn't like a little behind? If you don't know about this case, this is Georgia versus Christopher Wolfenbarger, I think, maybe. And an interesting case because it's been a cold case for almost 25 years. And the victim was found with a bleached skull, never found the torso. They found other parts in black plastic bags. And it wasn't identified. It then got identified when the victim's dad was. My hair looks like shit today. I need a haircut. When the victim's dad was convicted of 3 unalivings back in the 70s, they did a DNA swab and said, hey, let's just check if it might be his daughter that's missing. It was. And they started looking at her husband, who had previously, before she disappeared, there had been some DV going on in that family, but he claimed that she just walked out on the family, him and her 2 small children, moved to Califas to start a new life. And police was, yeah, we don't believe that, but we can't prove it. When they found out the DNA was from her, they also found out he worked almost across the street from where the body parts was found, in a wooded area in Atlanta. So, but still, the case, they couldn't prove it. They had nothing to link him with it. A crime scene investigator started looking back at this case in 2017, but not until 2024 did the police go and arrest him. When they went to arrest him, he was hiding behind a dryer in the house. This case potentially has it all. I'm just saying. A serial killer dad, a victim who we don't know why or how was unalive, and a defendant where I am really looking forward to see how the hell a new witness can come forward after 25 years and what forensic material they have found that they believe is strong enough till after 25 years try this case. I'm not saying he because everyone, as always on this channel, is innocent until proven guilty. But it seems very, very not suspicious. Seems very impressive if this case couldn't be solved for 25 years, and then all of a sudden there were new forensic methods that could do something. So we need to know about that. Hey, Winosaur. Dejligt at se dig. I can't do anything, Holly Mac. I don't know, Sue. It hasn't been mentioned in any of the descriptions I read. But those kids are grown up now. They probably have kids of their own. I think the youngest was 1 or 2 years old, and the oldest was 4. So they'll be pretty old. And the victim was called Melissa. Just because our Marissa has a strange Georgia accent and is roughly the same age doesn't mean that this is actually the real Melissa and she did a cover up hiding her DNA. Absolutely not. But never ask Marissa about her dad, named after a famous Second World Kerfuffle general. They have nothing in common. I believe Marissa is 50 years old. Yeah. Let's get to it and do it.
Okay. We have the jurors filtering in, but I know we have some preliminary matters to take out. Mr. Fawcett, are you going to handle this by yourself, or do we give you the minute fines? Hilton and Mr. Wilson.
I would like to assist this judge, but I'm ready to go.
Okay.
Thank you.
Here we have it.
Apparently, this case could potentially have it all. Oh, and he's in a wheelchair.
Okay. Madam Court Reporter, you ready? Yes. Okay. This is going to be day 3 of the trial of Christopher Wolfenbarger, case number 24 SC 004201. I'll note for the record that we seated our jury yesterday and that they are filtering in ready for a start time of 10 a.m. Mr. Wolfenbarger is present here in the courtroom along with his counsel, Mr. McDermott and Mr. Samuel, and the state's counsel, Mr. Fawcett.
We are 10 minutes behind.
We had some preliminary matters that we needed to address this morning. I had wanted to follow up on audio and photographs that we were still working through in terms of what's going to be offered. Mr. McDermott, had you had a chance to get through those materials?
I have, and I emailed the Mr. Fawcett last night.
Okay. Do we have agreement on what's going to be offered?
We do not, Your Honor.
Okay.
I did take out photographs that defense counsel felt as though they were duplicative. I took out photographs that displayed the victim's skull. There's one that displays the location of the skull. There's several others that show different angles of it. I've eliminated those as part of my intent to show the jury the location and corroborate the evidence in the form of testimony. But this is a case where Ms. Wolfenbarger was, her remains were left. We know at least the extremities were out there in the elements for at least a 2 to 3 month period, because you have the skull found in April and you have the extremities found in June. And so that, just by the very nature of that, is going to lead to
1998.
But there are only 2 photographs of her extremity that were located in the woods on that June date. Obviously, there could be several of those photographs, but there are only 2. The autopsy photographs, we have eliminated several, and the intent of the autopsy photographs is to show some of the tool marks. But we anticipate testimony from our anthropologists as well as our medical examiner to say that they observed, they believe, some type of mechanical device, man action, that was used to separate the skull from the neck. and the femur bones from the torso. And so all that's relevant evidence and markings on that show the jury the marks that would be testified to, as well as corroboration of testimony. And I would submit to the court Davis versus the state. That is a Supreme Court case, 306 Georgia 140, 2019 case, specifically deals with defense objections as to the gruesomeness or objectivity, prejudicial effect of crime scene photos and
Right.
homicide cases.
Yeah, and I mean, and let me save y'all some trouble. I am not of the opinion that just because things are gruesome, that they are somehow prejudicial. If they're relevant, then the court will conduct an analysis under the appropriate rule of whether it's overly prejudicial as is required. I think what I was hoping for is more to avoid accumulation, right? And so that what you're presenting is the evidence that's necessary and relevant to your case, and not, let me show you 9 pictures of the same gross thing that we all really don't want to look at when maybe 1 or 2 would suffice. That's really all I'm trying to accomplish here. And if you're going to show 9, I want to make sure there's some particular reason that that's necessary and that I've conducted the analysis I need to ensure that it's not overly prejudicial if that's what you're doing.
Well, if I can split these up. And I'm
Sure.
gonna start with the autopsy photographs.
Okay.
If I'm looking at the autopsy photographs, the intent was to show each different section of the body that was discovered, as well as the tool marks that would be testified to.
Okay.
I do not believe there are any duplicative photographs.
I had just gotten out of the Navy
body
in
that was
98.
located. I don't believe there are any duplicative photographs of any of the tool marks as it relates to the images I intend to show from the autopsy photographs. As to the crime scene, obviously there are going to be photographs of what the crime scene looked like without the body there, because the body was, transported to the remains. But it's important for the jury to have a context of where the location of the skull is located. There will be some testimony that they believe that there were dogs that were carrying the skull, or bag they believe the skull was in, from the wooded area where the extremities were located to the street where the skull was found. There's going to be testimony that that same dog had to be shooed away. And I think that as far as where the skull was found, where the sewer is, and the proximity of that to the job, I think is particularly relevant. And I think specifically as it relates to that Davis case, specifically crime scene photographs that are indicative of the location of where relevant items are pertinent. And although they may be prejudicial, I hope everything that I present is that prejudicial effect is not outweighed. I think that this evidence is relevant, and I think it is necessary for the jury to see some of the photographs. And I mean, I guess ultimately what I'm saying is I don't have any issues taking direction from the court. You're a fact finder, so if you independently feel as though a certain portion of the photographs don't need to be played, that's fine. But what I got from the defense, I think, was limited in what they were willing to agree to. I didn't feel like that would have been representative of the case.
Okay. Thank you, Mr. Fawcett.
Yes.
So, Mr. McDermott, let me ask a couple of questions as you begin your argument. So I'm assuming for your record, you want to state your objection to all of them. Is that fair?
No.
No. Okay. Well then, because really what I'm trying to get down to is if we assume that some universe of those photographs are going to come in, then what I'm trying to get to is what are the particular aspects, which particular photographs do you object to and why?
Well, I sent him the list last night.
Mhm.
It's my understanding he was going to submit all that to you. And
Okay.
go through them one by one, but really what he described is actually my point was. I'm not objecting to showing a head in the road as it was found. I mean, that's obviously relevant and important to the crime scene. As far as the discovery of the limbs a month later, there are only 2 pictures of that, 1 limb and 1 black bag. Well, I take that back. There are a couple of other black bags. I don't object to those. When we get to the autopsy photos, I understand we need to show tool marks because they're going to testify this was a saw, and we'll have a discussion about that. But do we need to see this is the left foot? No tool marks involved. Nothing about the crime scene. Nothing about cause of death. Nothing necessary to explain anything the medical examiner did.
So,
And then now the right foot. Well, let's look at the right elbow. Let's look at the
right.
left.
No, I understand that, Mr. McDermott, but I mean, setting aside that we're talking about body parts instead of one entire body, I mean, it is fairly standard to show for identification purposes, this is the body that was delivered to us. And after we cleaned it up, the condition that it was in. And usually the arguments I'm having are, but please don't show where you took off the front of their face to inspect their brain. And so I guess if that's the typical way that it's presented, then why would, here's the left foot, here's the right foot, here's the right arm, here's the left arm, here's the skull, at least those minimal baseline photographs, why wouldn't they be admissible? Why would they be overly prejudicial or not relevant?
I think the repetition of it, but in addition to that, we have multiple pictures of bones after the flesh was, as we understand it, steamed and cooked off of. that's not necessary for them to determine anything. The tool marks were visible without that. Why do we need pictures of the bones laid out?
Okay.
In an array. So if we could just limit it to what is absolutely necessary to get it across.
Okay.
I think that would be helpful.
So to that end, forgive me, I'm going to let you continue making your record, but to that end, I think what needs to happen then is, Mr. Fawcett, if you have a list that was provided to you for Mr. McDermott, if you can just email that to me, so that I can take this flash drive. Are the exhibits identified by exhibit number on this
Is
flash
this
drive?
flash drive
Mr. Fawcett?
a real flash drive or
Yes,
something?
the exhibit
without
numbers
it?
are listed on the exhibit.
Okay,
Evidence?
so I should be able, what my intention is to go through,
Hey, Adrian.
and look at the ones where Mr. McDermott has asserted an objection, where the parties don't agree, and then just go through, and then I can go through them one by one and provide you with rulings on their admissibility.
And let me just add, as far as the flash drive goes, it's one PowerPoint file, and the numbers of the exhibits correspond to the numbers of the slides in PowerPoint.
Thank you. That's very helpful.
I just also want this put on the record that there's I don't know what to call this. This is a printed out list of photographs that was included in the original discovery. I have never been able to find out who created this document, and we've never been provided with these photographs. There are multiple photographs clearly describing the crime scene where the limbs were found. And by my just looking at it, probably about 36 photographs. And I think that would actually be more helpful than the autopsy photos. But I would just love to find out who compiled this list so I could cross-examine them. And I've
Okay.
been asking for that for several days now. Don't get an answer. So
Okay.
put that on record.
Mr. Fawcett,
Yes.
you're gonna email me the list that you and Mr. McDermott have exchanged?
Yes, Judge, I
Oh.
just did that.
Okay.
You should get that. And I think when we first started at the arraignment for this case, the court referenced how old the case was and how sometimes there may be documents that may not be able to be produced. When we first indicted the case, we went over to the Atlanta Police Department, the annex, to retrieve and physically review files. Before the case was indicted, I went over to the Atlanta Police Department and reviewed the officer's original file. We did that again a month after the case was indicted, just to ensure that we were complying with the court's discovery request. I believe that was required
No,
at the end of that year.
heard that, Dad.
And shortly after that, we got
For those who have been sneaking in since we started, this case is about Melissa Wolfenbarger, who disappeared sometime around Halloween 1998. Her husband claimed that she had left him and the two kids, moved to Califas to try and start a new life. Never ever heard from again. In April 1999, her bleached skull is found in a wooded area near Atlanta, Georgia. But they can't figure out which skull it is because it's just a bleached skull. Weeks later, her arms and legs are found in black plastic bags near the same area. Apparently, we just heard a little snippet about it. Some dogs were getting into it, so pictures will probably not be pleasant. They don't know who it is. But in 2003, her dad is arrested for 3 unalivings back in the 1970s. And they say, hey, we have this unidentified body from a female from 5 years ago. Let's try and use his DNA swab. And they figure out this is Melissa. Her husband is a suspect, but they have no evidence. The case goes cold. Nothing happens. The mom and sister has tried to keep this case in people's minds, but the police couldn't really do anything. They couldn't prove what happened. So it went cold. In 2017, crime scene investigator who likes to dig into these cold cases starts looking at it. And because of a new witness allegedly and some new forensic tools, in 2024, Christopher Wolfenbarger is arrested. When the police go to arrest him at his house, they can't find him at the house. But they then find him hiding behind a dryer. So this case is going to be very interesting. First of all, there's the whole story. A serial killer's daughter was unalived. That's weird to begin with. But how can they find new evidence 25 years later? His defense team have said, this is ridiculous. We've been waiting for 25 years and nothing has happened. And then all of a sudden they can prove it and a new witness. So it's a very old cold case that turned hot a year ago in August last year. I think he was arrested August 9th last year. So it's actually gone to court really fast. And by the way, this afternoon, before everyone starts asking, I will end this stream, take a short break, and then Marissa has found the Zoom number, I think, for the Walsh hearing. It's the same as last time. Yeah, but I don't remember stuff. So we will cover the Wall stream at 2 p.m. today to figure out, will we finally get the Proctor data, or will we keep kicking everything down the road? If they start at 10 o'clock tomorrow, I'll start a bit early and we'll catch up with the afternoon stream. We will get there.
Request from the defense. I offered for the defense to come to our office to view our discovery. I think after we had the motion to compel, I advised the court that I had offered them to do that. I made another offer to do that. And I made a third offer in writing, emailed to Mr. McDermott, I think maybe 3 weeks ago. Last week, Mr. McDermott emailed me and asked me what day would be a good day to come over and view our file. And my intent was to make the Atlanta Police Department lead detective's file available, Detective Shepard. And my intent was to go back to the annex. I know how important this case is. Go back to the annex and look at it again. Part of doing as much due diligence as I could. I offered Mr. McDermott, I believe Tuesday and Wednesday of last week to come over and view it. When we talked, we discussed the discovery. We didn't discuss that date. I assumed he no longer was interested in that. But I've looked in every file that we've had. I've looked at the annex. I've looked at our digital files multiple times. And every document that we have in physical paper form and digital form has been turned over to the defense. I don't have any other documents.
Okay.
My complaint is not that I don't have enough documents or that these photos are missing. I can understand that that's the case. I just want to know who made this document and can I call them as a witness? And that's not unreasonable. They have access to Mary Beth Optel. They have access to T.R. Miller. They have access to all the investigators who worked on this in the Calhoun days when this would have been created. And they can surely find out who created the list of photographs and their descriptions so that I can cross-examine.
And yeah, I did inform counsel that there were 2 investigators that were working on this case. It was Mike Alsop, whose name is in the discovery, whose name is on several.
Hang on, let me back up for a minute. Do you know, is the issue that you don't know who created that document?
I don't know who created that document, but I can say that.
Right.
There were
Okay.
2 investigators that could have created it.
Sure.
Mike Alsop, who was an investigator for the Polk County Medical Examiner's Office, and investigator Tina Miller, who is on the witness list and going to be testifying, who was also an investigator. That's an investigative report. And there was one of those 2 investigators made that.
Okay.
I mean, I guess I can wait till she's on the stand and roll the dice.
Well, have you had an opportunity? I mean, I assume those individuals were identified to you either specifically as people with information
Yesterday.
or on documents that were in the file in terms of reports that would have been provided through discovery of their involvement in the case.
I mean, they have been on the state's witness list. But
Okay.
as far as their involvement with these documents, I didn't know, and I learned that yesterday.
Okay.
I still have time to try to call them between now and then, although I think T.R. Miller's scheduled to testify today. So.
Okay. So here, I think that if the state has identified that they don't know who created that document, but that it could be either 1 or 2 people, and those people are identified as witnesses, or through their role were identified in terms of their involvement in the case, that they've been identified sufficiently for purposes of discovery, and that to the extent that one of them is going to testify, I don't think it's unreasonable for you to ask to, inquire with them before they take the stand. Hey, is this a document that you created?
Go ahead. Those names were mentioned to me yesterday.
Mhm.
I was not told, we don't know who did this. You'll have to pick from these people and find out for yourself. I was not told that they didn't know. I was under the impression that they were still going to try to find out more.
Well, I understood from Mr. Fawcett's answer that he did try to find out, and he hasn't been able to find an answer, that it's got to be one of these 2 people.
Then there was
But-
some communication yesterday.
Well, yeah, I think co-counsel has a suggestion. I'll reach out to the original detective,
Mhm.
Calhoun, I'll forward these to him to see if he can assist. He may have the name of a crime scene detective would have created that document.
Okay,
I'll do that.
thank you. Anything else on the topic of photos for now, Mr. McDermott?
Not those photos.
Okay.
They didn't ask
Well,
about
there were
those
two sets of photos we were talking about. One was the list of photos that has not been produced to you, that Mr. Fawcett says do not exist as far as he's aware, digitally or in paper. And then there was the second set, which are the ones on this flash drive that I'm going to look at and rule on. I have now received Mr. Fawcett's email regarding the ones they intend to offer that I need to actually look at in terms of your objections. Any other issues on photographs that we need to address?
I'll just say yes, because Mr. Fawcett just gave me this morning a stack of new discovery. And well, about half of this is stuff that's old discovery, and about half of it is new discovery that would have been nice to have even just a week ago. But these are cards and letters and photographs written between Norma Patton and allegedly Melissa. And I mean, it's just dumped on us right before trial. So that's a discovery violation, in my opinion. I've heard tale of these cards and letters for ages now.
I believe I heard you.
How can they drop communications between Melissa and her mom the night before trial when she's been dead for 25 years? Is Georgia the new Massachusetts?
During pretrial arguments say, where are those cards? Where are those letters? Right. So
Recently? Yeah.
on Monday during pretrial, when we were talking about statements
Well, it's
by,
nice to have an answer to my question. I agree with you. But still a discovery violation. That should have been turned over if they existed, which they did.
Because the woman he killed was the daughter of a serial killer.
That should have been turned over a long time ago.
okay, and we can talk about that when you're ready to talk about that. But those aren't photographs, and we're not talking about that just now.
Well, there are photographs in there. So.
Okay. But I'm assuming not the graphic ones involved in
Well, I was
Ms.
trying to be clear
Wolfenbarger's
that
death.
it doesn't pertain to the four. I'm sorry, that's my fault, and I'm being a bad boy. I just admit that's my fault. You said any other photograph.
Sure.
I made that jump. So.
That's fine. What about the audio of Mr. Wolfenbarger's statement? Have we agreed on the portions that will be played for the jury?
I think we have an agreement to the 80-90% of it. There's a portion we've agreed to start at 15 seconds earlier. I'm agreeable to redact a part in the middle that counsel has requested. There's a part.
Yeah, I think you have to have 3 before you technically are a serial killer. So he had 3 victims.
Towards the end, where the lead detective is asking a question and he is indicating his theory about where the skull was possibly washed out of because it was framed the previous day.
The detective is saying that?
The detective is saying
Okay.
that to Mr. Wolfenbarger, and Mr. Wolfenbarger responds the way he does. But I think there's other evidence that the skull was likely dragged out of the wooded area. So the counsel is requesting to redact it. I don't think it needs to be redacted. I think of scenarios where officers ask and make.
Again, this guy is accused of unaliving his daughter, Melissa, who is not Marissa before she went into witness protection. But she would have been 50 years old like Marissa is today. They found out it is Melissa's body parts they find because her dad, Patton, and I can't remember if it was the Green River killer or whatever, was arrested 4 years later and found guilty in killing 3 people back in the 70s. So her dad is a serial killer and she is allegedly unalived by this guy. So the twisty twist is the twisty twists. So yeah, this is a weird case.
All types of statements to defendants to elicit a response or see if there is a response. I don't view that as any different. If Detective Shepard and Detective Layton are asking Mr. Wolfenbarger a question, even if they are misrepresenting the crime scene, courts have said that it's not to say that was the intent of what was happening. Courts have even approved officers lying to defendants or suspects. So I don't think that this is a situation where that was taking place, but certainly, even if the crime scene was not in line.
Her daddy was the serial killer. Her husband is the one who is alleged to have killed her.
With other theories, a question about that to the defendant shouldn't be excluded just because it may not line up with other theories. It still elicits a response from the defendant that I think can be relevant for the jury to consider.
Mr. McDermott?
Yeah, my concern with that particular statement is not that it's just some random theory of the detective. He's not telling a lie. There are some speculation in the early police reports that there may have been a weather event that washed the head out into the road that clearly was picked up and used by later detectives. For example, Detective Shepard has used that theory when speaking not to Mr. Wolfenbarger, but to other witnesses as explanations for how the head may have gotten there. So clearly this is something that was important to the investigation, and they weren't treating it as a lie to try to get a reaction.
I'm not talking about your
and
wife.
Particularly Sergeant Layton's statement
I know
in that
she's your
video
cousin.
is correcting or trying to help Christopher with his understanding at the time. And he says, it is my understanding that there was a strong flood of water that washed this out into the street. So that's how it got there. And
Everything I said he only got convicted for 3. Or everything I read.
he says it in such a way that I'm afraid the jury will take that as evidence that something happened. He says it in such a confident way that it's his understanding. I think it will confuse the jury.
Is that individual going to testify?
There are 2 individuals there. The Detective Layton is not scheduled to testify, but Detective Shepard was there. He's on the video. He introduces himself to Mr. Wolfenbarger and is present throughout the entirety of the interview.
So that was my second point I was going to make, is that Sergeant Layton is not on the witness list, and he's not going to be able to testify on that point. So
We haven't started
yet.
yet.
Confused about that. So at the very least, if we don't redact that, if the court would provide some limiting instruction on that point.
I'm not sure what the limiting instruction would be. It seems the reason I asked about whether the witness or some witness could testify about the circumstances of that statement, certainly with knowledge of the investigation, is that seems like a topic for cross-examination.
Okay, fair.
In terms of whether that was accurate or whether you have information indicating that it was accurate. So I am going to the extent there was an objection as to that particular question, I haven't heard anything that would require it to be removed currently. The objection, as I said, is more subject to a subject for cross-examination of a witness that would testify about those conversations. Given that ruling, if we then have sort of a universe of agreed upon audio, if y'all can please reduce that to some secondary exhibit, which will be what's played for the jury, with only those items that either the parties have agreed or I have ruled will be admissible, that can play as continuously. And then, as I said, when we're ready to play that, I will instruct the jury that there may be, jumps in the video. There may be things, it may appear to them that things have been removed.
They had
or that it's been
DV
edited
trouble.
and that it's been done at my direction, and that they're not to draw any conclusions from the fact that things have been removed from the video or audio, and they're not to speculate about what might have been removed when it's time for that to be played. What exhibit is that going to be, Mr. Fawcett?
That is going to be, and I do have a list for the court. I just wanted to see what the ruling was. Let's see. That is going to be Exhibit 30.
And so y'all are going to have an Exhibit 30A, which is just the relevant portions that we've agreed on. Is that right?
You can do that, yes, yes.
Okay, thank you. As I said, what I'm just trying to avoid I'm going to start it and stop it, and then I'm going to start it and stop it, and we just have something that we can agree to play. It is more efficient. Okay, couple of other issues. So I have spent a good bit of time with the forfeiture by wrongdoing issue that was raised by the defense. Specifically, I've already ruled that non-testimonial statements that Ms. Wolfenbarger made to family and friends, that those family and friends can testify about those statements. There is the secondary issue, though, was that there are statements, as I understand it, there are statements made by Melissa Wolfenbarger in court records in service of a TPO application and to police officers as part of, I think, an investigation into that initial event that occurred, I think, on Brookline Avenue, if I'm remembering correctly. And that those are, I think everybody agrees those are testimonial in nature, and therefore they implicate the confrontation clause. And the state's argument is that those statements, that Mr. Wolfenbarger has waived his confrontation rights as to those statements because of his wrongdoing in causing the absence of Ms. Wolfenbarger. So as I understand that provision, it isn't just that the defendant, that the state can demonstrate by a preponderance of the evidence for purposes of the application of this exception, that the state can demonstrate by a preponderance of the evidence that Mr. Wolfenbarger may have caused Ms. Wolfenbarger's absence. It's that they have to demonstrate that second piece, which is that the purpose of the causing the absence was to prevent the testimony. I don't have it up right now, but what I looked at a bunch of case law. The most recent one I saw was from Judge Dillard in the Britton case. And I found that to be particularly educational, because what Judge Dillard does is spends about a paragraph explaining the circumstances of that witness going missing, and that was satisfactory to the Court of Appeals that the defendant may in fact have caused the person's absence. But then importantly, they add a sentence that says there was evidence in the case that the defendant had made a statement to, I think, a cellmate that the defendant was not worried about that witness testifying. And I think that's the concern I have here, is that we have evidence that the state absolutely can satisfy by a preponderance of the evidence that Mr. Wolfenbarger may in fact have caused Ms. Wolfenbarger's absence. What I'm not sure I have is evidence other than potentially an inference from the circumstances, but that inference has to be reasonable to satisfy the preponderance standard, and I'm not sure I have enough. And so based on what I have heard so far from the state, I don't believe that they've satisfied the burden to demonstrate the forfeiture by wrongdoing standard. And so, as I said, to be clear, I believe they've satisfied and demonstrated by preponderance the evidence that Mr. Wolfenbarger may have caused Ms. Wolfenbarger's absence, but I've not heard evidence that either establishes or from which the court could draw a reasonable inference that the purpose of that absence, the purpose of his alleged action in causing her absence, was to keep her from testifying against him in the domestic violence or TPO matter that was pending at the time. And so that's going to be my ruling. Mr. Fawcett, you want to make a record regarding that issue, sir?
Not necessarily that I accept the court's ruling. I do have several exhibits that are certified that are representative of that criminal case, such as the petition. There's a Rule 9 side setting the court date down. There's an order restricting contact, and then there's a request for dismissal by Ms. Wolfenbarger. I would still believe all those documents are relevant, but I would still be asking the court to allow the state to turn those into evidence. I would not be publishing the portions of those documents where Ms. Wolfenbarger is laying out the testimonial statements.
Right. Well, I'll hear from Mr. McDermott, but on its face, I agree with you that the existence of that case is not a matter, it is subject to a different hearsay exception that would allow potentially its admission, and it would seem to be relevant. But we were talking specifically about the statements of Ms. Wolfenbarger to officers and or in those documents. Mr. McDermott, your thoughts on that issue, sir?
Well, we would like to see his proposed redactions.
Sure.
What he wants to do, and be able to talk about that perhaps over lunch.
Mhm.
And go from that point.
Okay. I mean, I'm not ruling that they are admissible because no one's asked me specifically, but as I said, at first blush, I tend to agree with you that those would be relevant and potentially admissible under different hearsay exceptions. Anything else there was a motion in limine that was filed by the state, I think last night. And I need some help with it because I wasn't quite sure I understood what we're trying to limit. Obviously, we've understood for some time now that the fact that Carl Patton is a convicted murderer, right, was going to come into evidence in some manner, right, that was going to be an issue in this trial. So I'm not exactly sure what you're asking me to allow or to forbid. Can you help me, Mr. Fawcett?
So I guess this laid out in the motion. This is, as of the past week or so, I think it kind of gives me some insight into what possibly could be asked or attempted to elicit during the course of the trial. And as I've laid out, the only reason why Ms. Melissa Wolfenbarger's father is relevant in this case.
Jamie, is Iris still alive? Iris called me just when I took my nap, and apparently Jamie has been continuously trying to unalive her since she arrived in Winnebago or wherever Jamie lives.
This is because his arrest really jumpstarts the identification of her. And I don't know when she would have been identified, but for the infamous arrest of her father and him saying, "Find my daughter." That's pretty much what we've heard repeatedly by the medical examiners, the lead detectives, and everyone involved. But to take that information and now to attempt to introduce letters from Carl Patton, to what I'm trying to avoid is a relitigation of the case involving the Flint killer, because all the particulars of that case simply aren't going to be relevant for the determination of whether or not Christopher Wolfenbarger murdered his wife. So it's one thing to say, well, he was arrested. It maybe is relevant what he was arrested for, maybe. But outside of that fact, and the fact that that arrest triggered the identification, that's what the detective, Bruce Jordan, was the notifier to the medical examiner's office of that missing woman, Melissa Wolfenbarger. That triggered the retrieval of the dental records from William Brandon. And that was the comparison that made that identification. So outside of that, what other relevant parts of the case would be admissible? I don't believe that the statements of Carl Patton would be admissible.
The case hasn't started yet. We don't know anything. These are pretrial hearing things where they're going through the last things to admit to court or not. There was a history of her having a restraining order against him, but we don't know anything. It's a case that's been cold for 25 years, so this is going to be very interesting to see what they have that they believe links this to Wolfenbarger, that it has taken them that long to press charges against him.
I don't believe that the particulars of the case itself would be admissible. So I don't believe that the defense should be able to ask no fact. Well, tell me how many people did he kill? Tell me the circumstances of that. How is that relevant for whether or not Christopher Wolfenbarger killed Melissa Wolfenbarger? It just is not. And I think that in particular is something that could confuse the issues in this case in the future.
Okay, Mr. McDermott?
We disagree, Your Honor. We think that the only point of relevance being that he helped them identify who she was is just the tip of the iceberg. There's an entire developed body of case law which has been even more developed recently by the Supreme Court regarding evidence of third-party guilt. This is a classic whodunit case. The state has only circumstantial evidence that Christopher led to the death of Melissa. We have substantial evidence that there could have been other people who were involved in her death. And the Supreme Court has recently said the standard for third-party guilt is basically going to be 401, 402, 403. And they have telegraphed that in their most recent opinions. Even though it's not the precedent, I'll grant you. They've telegraphed that. They've said the test is going to be, if this evidence makes it likely, tends to make it likely, using the relevant, I got it off my head, the rule for relevance, more or less likely that he's guilty,
right? Yeah.
then it's relevant. And then it's only a 403 test after that. Well, Carl Patton's murders, it's not just he killed 5 people back in the 70s and that was it. It's why he killed people. It's his motives for killing people. It's who he killed, his friends and family, the way he killed them, wrapping them up in bags and dumping them in the river. It's the fact that he drove miles and miles to try to hide bodies. It's the fact that Norma Patton, who's going to be testifying here today, was right there hands-on helping him for 2 of those murders. She helped him. And what I intend to ask her about is only what she testified to in court. It's a certified court record that she helped. She helped plan the murders. She helped watch. She was in her living room. They shot the people. They fell. She helped clean up the blood. She helped carry the bodies out.
So let me
What?
stop you for a second and set what I think are going to be 2 signposts here before we get more granular, right? One is the fact that Mr. Patton exists, that he is a convicted murderer, that he, I think, was briefly considered a suspect, although my understanding is obviously the state changed its mind and decided that it wasn't Mr. Patton. But all of those things are relevant. And I think that the state can't limit the relevance of Mr. Patton's existence and his history, right? Like how it's relevant to Melissa Wolfenbarger as a general proposition.
Well, potentially because she disappeared before he was arrested. It could be a third-party culprit kind of defense where they said, our guy didn't do it, but her dad really liked to drop bodies around. And apparently her mom helped him. Why isn't she in prison?
Also, certainly, I fully expect that if Ms. Patton, Norma Patton, takes the stand, that there will be a thorough and sifting cross-examination about her involvement as a credibility matter, right, and as a convicted felon or whatever charges she pled to. All of those things I think are absolutely going to probably come into evidence. As a general proposition, what I'm concerned about is that part you were just talking about in terms of satisfying 403 from a basic relevance perspective, and to avoid getting too far afield of the issues in the case is. My general feel is I don't really want to get into relitigating the circumstances of the murders that Mr. Patton committed unless you can show me the specific reason that they would be relevant to this issue. And right now we're just having a general argument and you're just making a proffer, but that's what I haven't heard.
Well, I would reiterate the points that I just did. They're certainly relevant to how these bodies were disposed. They're relevant to who was killed and potentially why they were killed. There's evidence that Melissa knew about Carl Patton's murders, which is something he kept under tight.
But again, that's the fact of the murders, you're talking about the circumstances.
It's a motive for the murders, and it would be a motive for this murder as well. That's evidence of third-party guilt. It's relevant.
Mr. McDermott, I think we're talking past each other.
Okay, I'm sorry.
I'm not saying that you're right now,
Yeah.
as a baseline guidepost general proposition here, I'm not saying that I expect the defense is not going to talk about the fact that Carl Patton is a convicted murderer. And I'm not saying that you're not going to cross-examine Ms. Patton about her involvement and that sort of thing. I'm also not saying that the fact that he's a convicted murderer might have some relevance to this case and whether Melissa had motive or whether that might have formed some motive for Mr. Patton to be this alternate theory of the crime murder, right? That's not what I'm saying. What I'm saying is I understand Mr. Fussett's argument to be, it sounds like you want to go in and let's have a little mini trial about the circumstances of each of those murders. And that's what I'm trying to figure out. Why would...
Don't be sorry. Ask all the questions. People in chat are normally really happy to help. If I do this, it just means read the Chiron, because sometimes I do stuff. Ask all the questions. Participate as much as you want in chat. People come sneaking in. They have to go to the toilet. They have to grab a cup of coffee. They have to get Jamie and Iris out of the car wreck because these 2 ladies will be a danger to society. Please, if you're new here, we have a very open chat. We try to keep it as loose as possible. Stay away from Zach. He's a weirdo. But other than that, the rest is nice people. And Sue. Don't talk to Sue. And if I feel like it, sometimes I'll stop and do an update.
Anything other than the fact that he committed murder, right? Even the numbers, even the names. But why would the individual circumstances of those offenses, other than potentially some leeway to cross-examine Ms. Patton, Norma Patton, why would that be relevant?
Well, can the court help me out here?
Yeah.
When you say, oh, I lost my point. I'm sorry.
Sorry.
In the last thing you said, obviously we would agree that the fact that he committed murder is relevant. But you're saying what more than that is relevant? You're asking me what beyond that would be relevant in this case. And I think anything that tests, okay, let me go back to the point. You're saying we don't want to relitigate this case. And you hear me trying to relitigate the Flint.
Yes.
What part about me reciting the facts that are on court records in a guilty plea hearing, what part of that is relitigation? These are just facts about how those murders happened, what their motives were, who they killed. Those are facts on record. Testified to under oath. There's no litigation happening. But those are facts
Brandon
on record that
is
are relevant to the facts on
sadly
not in this case.
not feeling well.
And that is directly
Please have
relevant to
him
third-party
in your thoughts.
Okay. So, Mr. Fawcett, as I understand the state's motion, it was an effort to limit the nature and scope of evidence that will come in about Mr. Patton. Is that a fair general characterization?
Absolutely, that's correct.
Okay. So,
And let me just say this, if I may.
sure.
And I sometimes make mistakes, but I don't know that we've received the transcripts that are being referred to by counsel.
Well, that's a different issue. Well, and when and if that arises, because I can't deal with all of these issues in a vacuum in the abstract, right? Some of these are going to have to come up in the moment, and that's fine. What I'm trying to do, which I think is the purpose of motions in limine, is to give the parties some general guidance about what's okay and what's not. And I think that Mr. Carl Patton's existence, history, and the fact that he was even briefly a suspect, the fact that Ms. Patton was allegedly involved in his murders or in cleanup, whatever, right? Those things are fair game. And I think that to the extent the defense.
So the dad was a suspect in his daughter's missing. Oh, this can be a very interesting case. Again, I want to know what this new information that took 25 years, but totally is strong enough to get him convicted. I'm not saying he didn't do it, but again, you have to prove it in a court of law.
I think those things are going to be facially relevant and not overly prejudicial. What I am concerned about, though, is confusion of the issues and prejudice that might arise if we go too far into the granular details, absent a clear showing of specific relevance of those details into the details of the killings committed by Carl Patton. And so that's my general guidance to you, understanding that as we start asking questions and get into the back and forth of actual witness presentation, you may satisfy me that it's necessary for you to go into the particulars of one or more of the particular
I'm
killings
as
by
new
Mr.
to it as you
But
are.
right now, in a vacuum, absent a particular showing, a more particularized showing of relevance, I'm saying stay up here at the 50,000 foot level and let's not get down into the weeds unless and until there's a showing that it's relevant for your purposes in this case.
So just to be clear, what I've already mentioned about the motives, at least in two of those killings, to keep people silent who were going to talk about his murders, is that 50,000 foot level, or is that down at granular level, or what are we talking about? Because a general motive for killing somebody seems to me would be directly relevant to this case.
So I think you're asking me to conduct a sort of quasi 404B analysis, right? In terms of, I understand Mr. Carl Patton doesn't have any 404B rights in this trial, but
also that's been specifically talked about in the case law.
I understand.
404 does not enter into the analysis at all.
I understand. I guess my point here is I've given you, I think, what are the general broad strokes. And so beyond that, I think you need to conduct your examinations of your witnesses in the way that you believe is necessary, and I will deal with individual objections as they arise. Again, my point is Mr. Patton's crimes, that they happened, that he was convicted for them, that Ms. Patton was involved in them. I think we're all expecting those are going to be relevant and discussed in this trial. I'm just trying to avoid getting down into the nitty gritty of it unless it's relevant and necessary for you. And if that's the showing that you're going to try and make, then I may agree with you. I'm just not going to do it right now. Okay.
As
Anything else I need
always,
to take up?
I have
Trial?
great marks.
Last thing, Your Honor. Good morning.
Good morning.
I know that there may be some witnesses that have criminal histories. I believe some may be older than 10 years. It is my understanding that we have not received any notice from the defense if they're going to try to impeach using convictions older than 10 years. And so I just wanted to bring that issue before the courts. I don't know if they exist or not, or if they plan to, but there needed to be notice if that was going to happen. And so wanted to kind of deal with that before a question comes out on the stand and we haven't addressed the charge.
Mr. McDermott?
Off the top of my head, I can only think of one that might be in that category. And in 1991, and it's not an impeachment issue. It's another third-party guilt. It's actually to explain one of the reasons Melissa ran away from home. And in 1991, her sister had a baby in their house. I don't know if it's unexpected. That certainly could have been unexpected, but she did it in secret. She didn't want to keep the baby or something of that nature, and tried to secretly dispose of that baby in a clothes hamper in their house.
What?
And we have court records from that conviction. I'll finish the story briefly. Melissa is the one who found that baby, and she didn't know what to do with it. She ends up telling people at school, and then the police come. Long story short, Tina ends up getting convicted for concealing the death of another in 1992. I don't even really need to talk about the conviction aspect of it. I just need to talk about the crime and what happened to Melissa. And it was shortly after that 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 was the final straw for her. She starts running away from home regularly.
What?
I do want to talk about that incident. If it's going to be an issue with the conviction or whatever, I'm not bringing it in for impeachment purposes.
So two things. One, I agree generally with Mr. McDermott's characterization that
Yes, Yo-Yo.
everything that all the circumstances that led up to whatever conviction occurred might be relevant with particular witnesses or whatever. And the fact of the conviction, it sounds like, is not really his target. Although I agree with the state that if you wanted to talk about that conviction, then I think there are some notice obligations. That's number one. Number two, though, is setting aside the notice obligations from a substantive perspective. The purpose of the rule prohibiting convictions older than 10 years is
It starts today. They are just doing the final motions before the trial is supposed. It was supposed to have started at 10 o'clock, but they are going through the motions, the final motions before it starts. So the next little twist: the serial killer's daughter, who was a victim of another murder, had a sister who has been one of the people trying to keep this case alive, who got convicted for having a birth in the house and hiding the baby so no one would find out. And the victim then found her, and her dad was a serial unaliver, and the mom helped him cover up those. I just read a quick catch up when I did my video this morning. I didn't know any of this.
because presumably they're stale. They're not particularly compelling or relevant to the veracity of a witness who's testifying now. But if we're talking about events that occurred more than 20 years ago, right, then the fact that they were convicted of something 22 years ago might be more relevant than it normally would if we're talking about a crime that happened last year and somebody wants to try and impeach or bring in evidence of a prior conviction from 10 or 15 years ago. And so that's my only concern. Ms.
Yeah,
Hilton.
understand that. And I guess this particular incident, what I think the state is having an issue with is the relevancy of Ms. Tina Patton having a child and Melissa.
So forgive me, Ms. Hilton, for interrupting you. I'm not ruling that that information is admissible. What I'm saying is that Mr. McDermott is not, to my ear, indicating that he intends to offer evidence of a conviction of that witness, which means there would be no notice obligation, number one. And number two, the issue about the substance of what he wants to offer, that I'm going to have to deal with that when it comes up. I don't know what the relevance is yet because I don't know why he would offer it. He seems to think that he has some facial basis to make a showing of relevance at the appropriate time.
Maybe.
Thank you, Ron. I definitely understand the notice requirement. If that's his understanding, my concern now, hearing what he may offer it for once the witness is on the stand, is that we can't unring the bell once he asks whatever question he asks in a moment for me to object. If he asks, did you kill your baby and leave the baby at home? And then I object, that question is already out and for. So if he's going to use, I want to deal with it, maybe an emotional limit, that's not relevant. But I'm not fully understanding all of the facts that he would like to bring in, since I'm just hearing about it now.
Mr. McDermott, why is it that you believe, I assume that you're going to go into, you plan to go into that when Tina Patton is on the stand?
I intend to mention it in opening, actually, Your Honor, because one of the key issues running through this trial is Norma Patton's claim that she had a loving relationship with Melissa. And we're going to put up lots of evidence that that's not the case. That Melissa wanted to come back home and Christopher wouldn't let her. That Melissa kept trying to leave Chris and come back home to them. And it's just simply not true. And we have tons of reasons why. And one of the reasons why that led to her initially starting to run away is the discovery of this baby. And that was the last straw. And I think it's going to be a testament to the abusive and foul relationship she had with the people in that home and her opinion of them. And that's all relevant to why she did not have a relationship that Norma Patton is going to claim on the stand that she did have.
Ms. Hilton?
Your Honor, because Ms. Wolfenbarger isn't here, some of this would be speculation on the part of anyone to say this is the reason why she left home. So we don't even have credible, I believe, evidence as to this is going to be the reason why she went home, or one of the many reasons why she went home. So now we're on a fishing expedition to ask questions that are speculative in nature, as well as not relevant in this particular instance as to whether or not Mr. Wolfenbarger killed or murdered his wife. I think we're now going to essentially try to muddy the waters in this trial to put in all of this extraneous evidence, and it's taking away from whether or not Mr. Wolfenbarger killed his wife. And so this particular evidence of a baby being killed in a home or potentially being killed in a home, and this is the reason why she's running away, is speculation. I don't know who's going to testify to that. So when you start asking those questions, now you are bringing in issues that are confusing the jury without any clear evidence to that, Your Honor. So that is our position as to why the details of this particular incident is not relevant, Your Honor, in this case. It'll be speculative and it's not relevant.
Okay. I agree with you. If the defense tries to argue or to get a witness to say, isn't that why Melissa ran away or whatever, that's argument, right? But if Mr. McDermott can establish facts that created what he's going to argue was a hostile home environment that would not lend itself either to indict the credibility of those witnesses or to demonstrate why Melissa wasn't there, I think that's fair game. But again, I would like to caution that there is a risk here of confusing the jury, of inflaming the jury with things that are extraneous. And we're all going to be very cautious about engaging in that endeavor.
Thank you, Your Honor.
Okay, anything else?
Nothing, but I just emailed Ms. German for the Zoom link. I did intend on using PowerPoint.
Okay, Ms. Johnson, if you can hear me, or Ms. German, if you could make sure that the lawyers have the Zoom link for today so they can log in. Last thing, Mr. McDermott, anything else you need the court to address pretrial?
No, I'm not.
Okay. Last to take up, I do have all of my jurors. I did want to let you know that juror number, no, not that one, the dialysis. 43, who y'all will recall is the gentleman that we, that told us that he was on home dialysis. He has presented today, he is here, but he has also sent to my office a letter from a physician at Dialysis Care Center asking for that individual to be excused because he has a diagnosis of end-stage renal disease. My understanding is, I think the numbers indicate that he is an alternate, but he is here. I think there was a discussion on the record when we were talking about whether or not to excuse that juror for hardship that I think I and the lawyers asked him any number of questions about whether he could make it work. And it seems like maybe he doesn't think he can, but he didn't say that clearly during the process of voir dire. What are our thoughts on what to do with that? Now, I feel like if he's here, I need to inquire, is he asking to be excused, right? Because this letter, since he didn't say that, number one. Number two is if it's a matter of accommodating him from a time perspective, right? I can say, hey, well, I'll guarantee you we'll be out of here every day at 5 o'clock or whatever I might need to do to enable him to conduct his home dialysis timely. What are your thoughts, gentlemen?
I would agree with that, yeah.
I agree.
Okay. With your permission, I'm going to have, rather than bring him out here to ask that question, I'm going to have my staff ask, are you aware we received this letter? Because this letter was faxed directly to us from the healthcare provider. I'm sorry?
No, go ahead.
And I'm going to have Ms. Sherman ask him, are you asking to be excused? So that I can then make that clear to y'all, and then y'all can make a decision about whether we wish to excuse him or not. Everybody go with that, Mr. Fossett?
Yes, it's on to the defense.
Mr. McDermott?
I'm good with that.
Okay. Mr. Sherman, come here, please.
And now we're losing the first juror. And I am trying to make a... I predict I will soon be number one. Well, Zach, you are always number one on my list over the most... No, I won't call you annoying. The most engaging people in chat. Thank you.
Anything else while I wait for that answer? Okay.
So if we excuse him, are we considering getting another alternate? Or we haven't got to that stage yet?
Well, he is an alternate, so I mean, we would just proceed with only one alternate.
That was the question.
Yes, sir.
Proceed with one or go ahead and try to find another.
I mean, that's y'all's decision. I'll do whichever you ask. Logistically, seating another alternate at this point and getting them here from whatever corner of the county they reside in might mean that we're starting opening statements at 1 or 2 o'clock instead of at 11.
Come on now, it's not going to be a 5-week trial. Move it.
I'm told that he seems quite comfortable back there. That was one of the reasons I wanted to ask if we can accommodate you to make it easier. Are you asking to be excused, or do you just want us to be aware of this medical information? So I don't know that y'all can think about what your options might be if he says he wishes to be excused, but I don't know that we have to solve that problem just now because he might say he's fine. He'll take it day by day.
Come on, let's get started. So, interesting. Yeah, if you're on in-home dialysis, do you really want to sit in court all day long? I'm not impatient. I'm always more than willing to wait for a good case, and hopefully this will be a good case. But I have officially kind of lost my mind already because He is allegedly the unaliver of the daughter of a serial unaliver whose wife helped with the serial unalivings, and
So,
their other daughter
with
unalived the
y'all's
baby.
permission, Ms. German did inquire with juror number 43 whether or not he was asking to be excused or whether, you know, what the purpose of providing us with that information was. And he has communicated to her that he wanted us to be aware of the nature of it, that he reached out to his doctor, but that he's actually not asking to be excused. And so he has stayed and elected to remain. We did advise him that we would try to accommodate him to the extent necessary. And he mentioned a couple of things that we'll need to work with schedule. But nothing that I've seen that's too burdensome in terms of, you know, ending one day at about 3:30 or something like that. So, but we're going to go from there. So 43 stays. I just wanted you to be aware that I had that information from his doctor. Anything to put on the record regarding that matter, Mr. Fawcett from the state?
Not from the state, Judge.
Mr. McDermott?
Nothing from the defense.
Okay. So are we ready to get started? State ready?
Yes.
Yes, I'm going to share my screen now. with the court
Okay.
commission.
And have the parties had a chance to make sure that there's not anything significantly objectionable that, I mean, like, have you shown each other? I don't want to,
I did show counsel what
Okay.
I intended to show in the opening statement. I did not hear an objection.
Mr. McDermott?
I don't believe I got your full PowerPoint presentation, did I?
It sent to you, but
So I have not been able to look at that, right?
well, I showed you the photo.
Well, let me say this. Excuse me, gentlemen, I'm going to be talking to the jury for about the next 25 minutes. So I think you'll have time to look at it and then you can let me know if there's an issue. Okay?
Oh,
That was it. Yeah, showed you.
so as far as the content, you're not.
No, I'm not showing anything else.
Let's.
Your share screen works. If you'll take that down, please, while I talk to the jury.
Absolutely. Thank you.
We're ready for the jurors.
Am I correct? The mom's name was Mona or something like that. I think that's correct. I'm just making it up. I am actually trying to do something for the first time in my life. I'm making a whiteboard for the first time in my life. I don't know how this works. Maybe it does work. But just so everyone, stop this. No, why is that? This is what I have gathered so far. Chris Wolfenbarger is the defendant. Melissa Wolfenbarger is the victim. Her sister, Tina Patterson, allegedly got convicted in 91, 92 for unaliving her own baby in their house, and Melissa was a witness against her. And her dad, Carl Patterson, is a serial unaliver who's convicted of that, allegedly not allegedly, convicted of unaliving 5 people. And the mom, Mona, I think her name is, I could be wrong, apparently helped the dad with all of this. So did he know all of this when he married her, that all of these people are weird?
Thank you all so much for your patience this morning as we get through some of our processes that need to happen. I'm going to talk to you a little bit more about how this process will go and give you as much guidance as I can before we get started today. But first, counsel, is this your jury?
Yes, it is, Judge, for the state.
Yes, Your Honor.
Thank you. So ladies
Stop
and gentlemen,
squinting,
now that
you're
I've
giving
told
me
you
a
you can have a
headache.
seat,
You
if you'll
stop
please
squinting.
rise and raise your right hand. Members of the jury, do you swear that you shall well and truly try the issue formed upon this bill of indictment between the state of Georgia and Christopher Wolfenbarger, who is charged with murder and felony murder? A true verdict give according to the evidence, so help you God. Please say yes if you agree.
Yes.
Thank you all. Please be seated. So ladies and gentlemen, thank you all again for your patience. Sometimes things move a little bit slowly, and I promise you that we are trying to be efficient
Oh,
and
she's from
cautious
Chinese
of the
Willis.
importance of your
I didn't
time
watch
and
that.
attention throughout this. So ladies and gentlemen, we are now ready to begin the trial of this case, and I have some preliminary matters that I want to discuss with you. You'll see me reading a good bit, and that's because there are lots of places where it's good that the judge doesn't ad lib, right? And so I'm going to read some things to you to make sure that you understand what your obligations are and to provide you as much information as I can as we get started. So I've already told you about our deputies. They're an excellent resource for you in terms of asking questions about what the schedule is going to be, where and when you can go or not go. I'm going to try and give you some instruction about that as well.
Well, you have missed all the wonderful craziness that the family is. This case, for anyone who just came in, this case is to do with Melissa Wolfenbarger. She disappeared in 1998, just after Thanksgiving. Then a bleached skull shows up in 1999 in a wooded area in Atlanta. They don't know it's her because there's no way to identify it. Later, they find some pieces of the extremities in some plastic bags. Allegedly, some dogs was going at it with those. Still no identification. People are asking, where's Melissa? Christopher says, well, she took off to California to start a new life. Hasta luego. This case goes cold. In 2003, Melissa's dad is convicted as the Something Creek serial killer. Someone wrote it here. I read it before. Something Creek serial killer, or Something River serial killer. They take his DNA and test it against these body parts. It shows it's Melissa that's the victim. They still look at Christopher, but apparently they also looked at her dad because he was a serial killer. And apparently the mom also helped the dad with these serial killings. I didn't know that till we heard that before, because I don't deep dive before I watch trials. There's also a sister, Tina. Tina apparently could have been a reason why Melissa started running away, because she had a baby at the house in 1991 that she hid, and that baby passed away, and Melissa was the one who found it. So I'm thinking the defense will rely heavily on third-party culprit. Someone else in this absolutely cuckoo family could have done it. The Flint River Killer. Thank you, Serenative.
From this point forward, as you just came into the courtroom, you will only enter the courtroom through this door and only when accompanied by a deputy. So that means that when we need you to leave, the deputy will come and open the door for you and hold it while you go out. And when it's time for you to come in, the deputy will come in and announce your arrival. The deputies can also tell you a bit about our fairly meager offerings for lunch. I encourage you to consider bringing your lunch. We do have some options, but not a whole lot. And sometimes you'll be pressed for time. And I want to make sure that you do have an opportunity to eat and to make sure that you don't get hungry or distracted while you're serving as a juror. So I think all of you are wearing your juror stickers. If you would, make sure that you're always wearing those when you're in the courthouse. And that is for a very important reason. So from now going forward, the people in this courtroom, the witnesses in the case, the parties in the case, they're not allowed to have any contact with you outside of this courtroom while we are engaged in the trial. And so the reason that I ask you to wear those stickers is so that you can be identified as a juror should you encounter someone in the hallway. Now, if that happens, don't panic. just let us know, right? Now, what may very well happen is you may encounter a witness or a lawyer or a party while you are waiting on an elevator. If they go away from you, please don't be offended, right? They're not being rude to you. They're simply trying to satisfy the court's obligation and their legal obligation that they not have any contact with the jurors outside of this proceeding. So we will generally hold court from 9:30 to 5:30. I will tell you each day when we adjourn when you have to come back and what time you need to be back. And I will try to be very cognizant of taking breaks in the morning, taking lunch breaks, things like that, so that y'all will have a chance to have a break from what is the real, mental focus of being here in the courtroom. So ladies and gentlemen, you have been sworn and impaneled, and you are about to try a criminal case entitled The State of Georgia versus Christopher Wolfenbarger. Before we begin the trial, I'm going to give you some preliminary instructions on the fundamental principles of criminal law. I'm going to instruct you on the role of the judge, the role of the jury, and the lawyers, and give you an overview of trial procedure. Many of you may have never served on a jury before, and it is therefore necessary that these instructions be given so that you have a general understanding of
I have it sped up so we can catch up. This is just your instruction. It's not that important.
the procedure in a criminal trial, of what will be expected of you, and how you are to conduct yourself during the
I
trial.
will
The
recommend you
defendant in
to
this
bring
case
your
is
own
charged in
lunch.
the indictment with crimes that are violations of certain laws of the state of Georgia. Now, I want to emphasize to you that the indictment, including all of the counts in it, and the plea of not guilty, are the legal procedures by which these criminal charges are brought against the defendant. The
It's
charges
just your
and the plea of not
instructions.
guilty are not evidence of guilt, and you may not consider them as evidence or implication of guilt of any crime whatsoever. This defendant is presumed innocent until and unless he is proven guilty. This defendant enters upon the trial of the case with a presumption of innocence in his favor, and this presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the crime or crimes charged. Now, under our system, it is my duty as the trial judge to determine the law that applies to this case and to instruct you, the jury, on the specific rules of law that you must apply to the facts in arriving at your verdict. I'm giving you some of those instructions now, and I will give you more detailed legal instructions after the evidence has been presented and the lawyers have made their closing arguments. Now, during the trial, I may be called upon to rule on motions or objections to evidence. Nothing I say in making those rulings or at any time during the trial is evidence that I have any leaning in the case whatsoever. My only interest in this case is to see that it is fairly tried according to the laws and the Constitution of the state of Georgia and the Constitution of the United States. Now, as expected, these lawyers serve as advocates for their clients, and they are duty-bound to represent their clients to the best of their ability. The lawyers also serve as officers of the court, and as such are bound to follow applicable laws, trial procedure, and the rules of evidence during the trial. Now, if at any time the lawyers believe that any law, procedure, or rule of evidence is being violated, they're allowed to make motions regarding the conduct of the trial or objections to the admission of evidence. In making these motions or objections, the lawyers are simply seeking to fulfill their duty to their clients and to the court. Now, sometimes those motions may need to be heard outside the presence of the jury, and one of two things will happen. Sometimes you'll see us come over here, as I think you saw us do during voir dire, and we'll engage in a quiet conversation if it can be done quickly, and that's to minimize the number of times we might need you to leave the room. But sometimes those things require us to give it a little bit more time, and so we will have to excuse you to the jury room when we need to do that, and we will just thank you in advance for your patience and understanding that those matters are important when they are occurring.
If any of you have been watching the Nicholas Cassiotti's case on some of the other streams, there is a verdict in that one. So run off to Recovery Addict or where you have seen it if you need the verdict in that case.
We will try to keep them to a minimum, and again, to be cognizant of the importance of your time. Ladies and gentlemen, trial procedure in a criminal trial is generally as follows. First, the attorneys for both sides have the opportunity to make what is called an opening statement. Now, both sides are entitled to make an opening statement, but neither side is required to make an opening statement. Remember that what the lawyers say is not evidence, but it is a preview or an outline of what they expect the evidence in the case to be. Following the opening statements, the evidence will be presented. Evidence can be presented in the form of testimony that you will hear from witnesses who will take the stand, or physical evidence that will be labeled with exhibit numbers for identification. After the presentation of all the evidence, the attorneys will have the opportunity to make what is called a closing argument. Now, at this time, the attorneys may suggest to you which laws are applicable and how they should be considered in light of the evidence, and point out to you certain parts of the evidence that they think are favorable to their position. The goal of a closing argument is to persuade you to decide the case in their favor. Following the closing arguments, I will charge you more specifically on the law that applies to the case, and I will then ask you to retire to the jury room to deliberate and reach your verdict. The jury has a very important role. It is your duty to determine the facts of the case and to apply the law to those facts. I will instruct you on the laws that apply to this case, but you must determine the facts from the evidence. Evidence, by definition, is the means by which any fact in issue is established or disproved. Evidence consists of two things, either testimony or exhibits. Testimony is the testimony you will hear under oath from those who take the witness stand. Exhibits are those documents, photographs, or physical evidence that are admitted into evidence. Ladies and gentlemen, the object of this trial is to discover truth. And during the trial, the admission of the evidence will be governed by certain rules of evidence. Those rules were drafted with one prominent purpose in mind, and that purpose is the discovery of truth. Now, consequently, the rules of evidence seek to assure that only the best and highest evidence is admitted for your consideration. During the trial, the attorneys have a right to object to the admission of evidence if they believe that its admission would violate a rule of evidence. I will admit or exclude the evidence according to those rules. If I overrule an objection, that means that you are allowed to consider the evidence that is being offered. On the other hand, if I sustain an objection, that means that you may not consider the evidence that is being offered. Now, you should consider only that testimony and only those exhibits that are admitted, and you should draw no inferences and make no assumptions about the evidence objected to if the objection was sustained. Now, sometimes you might see or hear inadmissible evidence before an objection is asserted or before the court can rule on the objection. If that occurs, I may instruct you to disregard that evidence. And if you are so instructed, it is your duty to disregard that evidence in its entirety during your deliberations. You, the jury, must determine the credibility and believability of witnesses. It is for you to determine which witness or witnesses you will believe and which witness or witnesses you will not believe, if there are any that you do not believe. In determining the credibility or believability of witnesses, you may consider all of the facts and circumstances of the case, the manner in which the witnesses testify, their interest or lack of interest in the case, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, and the occurrences about which they testify. You may also consider their personal credibility as it appears to you from the witness stand. As the fact finder, it is your duty to believe the witnesses whom you think are most believable, and it's for you alone to determine what testimony you will believe and what testimony you will not believe. Ladies and gentlemen, it is important that you pay close attention to the evidence as it is being presented during the trial. And there are a couple of important reasons for that. Number one, there may be evidence that is admitted and presented to you to observe during the trial that you may not have with you during deliberation. And so it's important that you observe the evidence that is being presented to you when it is being presented during the trial. Also, as I mentioned a moment ago, observing witnesses as they testify is important. And so for that reason, I'm going to encourage you that if you at any time are unable to see or hear, or if you are suffering from some personal discomfort that distracts your attention, to raise your hand, let me know, and we will take a break or do what we can to address the issue with your being able to see the evidence or hear the evidence, or be comfortable enough to focus on the evidence as it is being presented. It is important that you view the evidence, ladies and gentlemen, with an open mind at all times, and that you reach no final conclusions until the trial is over. Do not jump to conclusions before all of the evidence is presented. Also, remember that during the course of the trial, it would be...
The Salati's case apparently has a verdict, so go to Catnat Williams, go to Recovery Addict, or who else has streamed it if you want to see the verdict live. I just saw it on the Twitter that there is a verdict in. And then come back and join us again. We all float down here.
Improper for you to discuss this case with anyone or to allow anyone to discuss the case with you or in your presence or hearing. This applies even to discussions amongst yourselves in the jury room or elsewhere before actual deliberations begin. I think you have been provided with notepads, so I want to take a moment to address the issue of note-taking. You are allowed to take notes, but you are not required to take notes. If you decide to take notes, please remember not to let note-taking distract you from observing the evidence in the courtroom as it is being presented. Your observations, as I said a moment ago, of the witnesses during their testimony can be vital to your determination of their believability, and the notes that you take might refresh your memory when you are called upon to deliberate. But importantly, the notes that you take are only to refresh your recollection. They are not evidence. They are only for you to recall the evidence as it was presented at trial. They are memory aids. It is the duty of each juror to recall the evidence, and while you may consider another juror's notes to refresh your recollection of the proceeding, do not rely on or be influenced by the notes of other jurors unless their notes help you in determining your own independent recollection. Notes are not entitled to any greater weight than the recollection or impression of each juror as to what the evidence may have been. Now, that's the conclusion of the introductory instructions that I need to give you. Before I call on the state, I do want to make sure that everyone is aware that the rule of sequestration has been invoked. And if there is anyone in the courtroom who anticipates that they will be called a witness in this matter, I ask that you please exit the courtroom and do not re-enter until you are instructed to do so or called by one of the parties as a witness. I also will just mention again, as I've asked the attorneys, you know who your witnesses are better than I do. And so if you'll just keep an eye out in case they wander into the courtroom so that we can get them out of the courtroom as quickly as possible. And with that, I'll call upon the state. Does the state wish to make an opening statement?
We do, Judge.
Okay, you may proceed.
Good morning. Good morning. This is the State of Georgia versus Christopher Wolfenbarger. It's been 27 years since 1998. And specifically, December of 1998 was the last time that Melissa Wolfenbarger was ever heard from. At that point, in 1998, Melissa Wolfenbarger was 21 years of age,
It's hot as balls in
married,
Denmark.
had 2 children, a mother, sister, and after 1998, December, neither one of them ever received a phone call, not a visit, not a card, not after Christmas of 1998, not after her mother's birthday in 1999 in February. So you're going to hear that Melissa, at the age of 21, she had experiences when she was a child when she would run away from home. She had experiences during her adulthood after she married this defendant, Christopher Wolfenbarger, when she would not talk to her sister for a period of time. But she would always keep in touch with her mother. Most importantly, she never let a holiday go by without calling or visiting. In November of 1998, Melissa had the intent to visit her mother for Thanksgiving. And they spoke. One of the things that Melissa was really looking forward to was getting a photograph of her pawpaw, her grandfather, the father of Carl Patton, Melissa's grandfather, and that is Carl Patton, Melissa's father, and that is the husband of Norma Patton. She wanted that photo, and Norma Patton expected that at some point between Thanksgiving, even though she didn't get an opportunity to go visit her mom, that she would get that photograph. But when Christmas came around, she was concerned when she didn't hear from her. But by the time she got to February, she knew something was wrong. Melissa never would let that much time go without talking to her mom, not especially during that period of time, not on her birthday. Well, it took some time for authorities to be alerted, because you're going to hear that Melissa wasn't reported missing until January of 2000. And that was because this defendant, Christopher Wolfenbarger, you're going to hear from his own words. You're going to hear what he told the detectives, what he told his children. He never looked for her. He never reported her missing. So when Norma Patton and Tina Patton are looking for Melissa, where is she? Not working anymore. She worked at Waffle House. Not showing up to a job. She's not looking after her children. She's not checking on her children. No word.
1998.
Well, the authorities tell them that, well, Melissa is 21.
Oh, he found the microphone now.
She's married. She's got her own life. If she hasn't called you, then maybe she doesn't want to talk to you. Her husband hasn't reported her missing. And you hadn't talked to her in a month. Well, not really much for us to do right now. But eventually, Melissa's mother goes to Henry County, and they start an investigation. But even though they talked to friends and family, they even talked to Christopher. And all we get from him is she just left. That's it. That
That's
goes
100
on
Fahrenheit.
for 3 years. She gets unidentified for 3 years. And that takes us to really when we locate the remains of Melissa Wolfenbarger. They were located on 2 different days. April 29th, June 3rd of 1999.
Was she an early cosplayer? It looks like Superman's suit with that red and blue. Oh, and it has stars on it. It's probably something patriotic. Forget what I said.
Now, April 29th, George McKeecher is driving on the area and heard questions about Avon Avenue. That location is the location of Action Glass Company. You're going to hear that is the location where Christopher Wolfenbarger works. The glass company, kind of a manufacturing plant. They have industrial equipment at this location. That's where he works. Although they had no reason to think that that was anything significant at the time, because in April 29th of 1999, all they knew that there was a head in the roadway, partially, fully, pretty much fully decomposed. And Mr. George McKeechen is driving in that area on Avon Avenue, and he sees something that he thinks is kind of odd. So he stops and looks at it, goes and gets his daughter and comes back, and he can see what clearly is a human head. Something that he would tell you he couldn't believe with his own eyes, or what he couldn't believe it. Well, that begins the discovery and really the process of trying to identify that skull. That's those same detectives, the lead detective at that time is Dale Kelly. You're going to hear from the Fulton County Medical Examiners, investigators, Tina Miller. They were all out there at the location on Avon Avenue, April 29, 1999, collecting evidence, taking photographs, some of which you'll see. But ultimately, they start looking for information on who this could belong to. Then you find the extremities on June 3rd, 1999. That these extremities are found, everything but the torso, or everything but the midsection of Melissa Wolfenbarger is located. Fingers.
I know glamour shots was a thing back then and stuff like that. Well, we didn't really do it here, but isn't her hairdo 1989? It's not 1999. Wasn't 99? I was a young strapping man in the late 90s. I'm 27 years old now, and I don't remember ladies having this hairstyle. This looks like something that ladies would have 10 years before.
And you'll hear from the detectives, you'll hear from the medical examiners. When the skull was found, they had a portion of the spine attached to the skull, and it appeared as though it had been severed or removed with some type of circular saw. The extremities were examined. Detectives, medical examiners, the anthropologists who worked for Fulton County Medical Examiner's Office, they observed signs of tooth marks. The anthropologist describes the different lines on the bones as what happens when a saw is attempting to catch a groove and actually make a cut. You'll see the bones where there's the saw marks on the finger of Melissa Wolfenbarger. you will see the end of the finger where it appears as though you see ridges on the bone where that saw. Okay? But even on June 3rd of 1999, they even had these cases connected. They were found about 50, 60 feet from each other in that same area. They didn't have a basis to connect to, so they were in the medical examiner's office as two separate case files. Skull found on Avon Avenue. And extremities found almost 2 months later on Avon Avenue. It's suspected that the cases may be connected, but they didn't have what you needed to actually combine and connect the cases and say that they were the same person. But what do you do at the beginning of a homicide investigation? The first thing that law enforcement does, especially when there's evidence of foul play, as in this case, when you find out who the victim is, who the person is, you go look at their background. And what did they find when they looked at what Melissa's life was like when she was alive, 97, 98? Who was she talking with? Did she have conflict with him? Is she married? What was her marriage like? Were there instances of abuse in the marriage? Had her husband ever been charged with anything related to that abuse, like hitting her? They looked at that information, and I'll tell you that at the time they did find the identity and were able to determine the identity of skull and extremities, Christopher Wolfenbarger was the primary suspect. I'll just tell you that. He was the person, the main person that they were looking at. He wasn't the only person, because you got to conduct a thorough sifting investigation, but they had evidence that Christopher and Melissa were involved in a tumultuous relationship, that Christopher was abusive, that he had struck her on multiple occasions. They had evidence that he had caused a black eye, that she had witnesses that observed bruises on her neck. They had evidence that at some point Melissa applied for a protective order to prevent contact with this defendant. You're also going to hear that on the day that Christopher was ordered to come to court, March 29th, ordered to come to court on July 29th, 1998, you will see that same day, Melissa appeared and requested for that case to be dismissed. Roughly 7 8 days after she was hit, 7 days after she went personally and applied for a protective order, 7 days after that, she goes back down to the courthouse and asks for it to be dismissed. I'm going to prosecute. You're going to hear from a lot of witnesses in this case. You're also going to hear from a domestic violence expert. And that domestic violence expert will be able to explain that that is not uncommon at all. The victims of domestic violence to come back and say, I want to prosecute. You're going to hear about some of the reasons why that can happen. And that was the 21st of July, 1998. Officer Marlon Sutton responded to the residence at 824 Brookline Street in Atlanta. That was the marital residence of Christopher and Melissa Wolfenbarger, the family owned home of the Wolfenbarger family that Christopher and Melissa were staying in at the time. When Marlon Sutton arrived at that location, it was a response to a domestic violence incident. And when he arrived, he got an opportunity to view Melissa Wolfenbarger and see her in person. What he observed was someone that had bruises, someone that had been attacked, someone that was hysterical and afraid. He didn't see Christopher there that day, though. He wasn't there, he left. So she was instructed to do as she did. You don't feel safe, go and apply for a protective order, which is what she did very instead. You want to see those documents she last week. The day after this, she goes down and files for that protective order. By the time this case comes up on March 1999, you'll see this document in particular, state court documents, actually filing the formal charge of battery against this defendant, 1998. By the time it comes to the court, they can't find Melissa. Can't find her in March 1999. No way of knowing a month and a half later, her head was found in front of his job. And I'm going to say this too. Less than a minute drive from his house in walking distance. You got this decomposing head, April 29th, in front of the job at Avon Avenue. And you got the location of Avon Avenue itself. So this is the Action Glass Company location right here. This is where Christopher Wolfenbarger worked. You'll see this map, and witnesses will explain. Witnesses that were at this location in April of '99 when her head was located.
Yes.
You'll see on the photographs there will be a sewer here, and you'll see where her head is located here,
Show us.
within about 120 feet from his job.
Okay, this is not legal advice, but if you're gonna unalive your wife, cut her into pieces, put some effort into it. Don't leave her within the distance of your work where you could spit on a good day. Hide her somewhere safe. Maybe do like her dad, toss him in a river or something.
And then in June, you'll see where the extremities, the sawed-off legs of Melissa Wolfenbarger are found in this area. The detectives will tell you when they examined the location, it appeared as though they saw an animal carrying a bag right where the head was located, from this area out onto Avon Avenue. So when they were able to make the connection, they come back with cadaver dogs, and they go back and look in this area, and that's how they find the extremities.
Put it on the screen where they found her.
That's how they find the June 3rd, 1999 legs, remaining parts that we found. We never found her torso, the remaining parts we found in this spot. It'll give you a perspective of where his job is and where Brookline Street is. This is Action Glass. This is the junkyard where the extremities were found.
We can't see where you're
Here's
pointing.
the location of the sewer where her head was found. And less than a minute drive is Brookline Street where Melissa and Christopher Wolfenbarger reside. Now, in 1999, you don't have the Atlanta Beltline. You don't have these buildings. This area is primarily wooded. But that is the location and the proximity of Christopher Wolfenbarger's job to where his wife's head was found, to where his wife's legs were found, and where they lived. This is a case about domestic violence. In addition to the evidence of the physical bruises on the person of Melissa Wolfenbarger, you're going to hear from her family. Her mother knew about the July 1998 attack. Melissa told her about it. She told her mother how Christopher was upset, wanted her to come back, and how he struck her in the face, how he grabbed her and dragged her by the hair. I'm glad he was arrested. Her mother was one of the persons that she told about that. July incident. You're also going to hear from her sister, Tina Patton, who occasionally works. Well, one time in particular in 1998, it was a 2 or 3 month period where Tina Patton, Melissa's sister, worked at a Waffle House. I believe it was Virginia Avenue Waffle House. They worked at a few Waffle Houses that year. Melissa didn't take her. But during
They
that
never
period,
found
the
the
early
torso.
part of 1998, Melissa and Tina Patton worked at the Waffle House. And she would tell you that there was one day that she observed while she was working with Melissa during that period, she observed marks on the neck of Melissa, around the sides, and she knew immediately it looked, and she'll tell you this, it looked like someone had choked Melissa. And Melissa told her that, hey, let's go out. And you're going to hear from a man that Melissa would have seen right when she died. You're going to hear that Melissa planned on leaving this defendant. You're going to hear from his own mouth that they weren't on good terms when she.
It does say Marshall residence. Maybe they're Martians. Is this around the time where people watched Mork and Mindy? I never watched that because it wasn't shown in Denmark. I just know it. But maybe they're Martians. That could be another fun twist. They're lizard people.
Yeah, when she went missing.
The judge was related to the YSL case. I don't know her name. I didn't watch the YSL case, but she has something to do with the YSL case.
Thomas Dixon was also working at a Waffle House when he met Melissa Wolfenbarger. And towards the end of 1998, they started seeing each other. And at one point, Melissa was staying in a lodge or hotel with Thomas Dixon. And he'll tell you that he was fully aware that she was with this defendant, Christopher Wolfenbarger, but he'll tell you that she wanted to leave. And during that week, she was spending with him. She fully planned on doing that, but decided to go back to him, to Christopher in particular, to see her children. She missed them. And Thomas Dixon will tell you that the last time he saw Melissa Wolfenbarger, Christopher Wolfenbarger came up to that Waffle House. Melissa and Christopher had a talk, and Melissa got hysterical. She started crying. Thomas Dixon will tell you that he went outside to talk to Christopher and told him that he has to leave until 9 o'clock when she gets off. You're going to hear Thomas Dixon tell you that when Christopher left, he peeled out in his Volkswagen, and that was the last time he saw Melissa. He'll tell you that she never came back to work at Waffle House. She never called, she never texted. And that is the evidence to show that that's consistent with what you'll hear from her mother and sister regarding the last time anyone was saw her. And as I said, she goes unidentified for 3 years. During this period, the medical examiner that is working in Fulton County is also working in Twiggs County, and is first attempting to determine if a headless corpse that they located in Twiggs County could potentially be connected with this skull they find in Avon Road in Atlanta. That was one thing they were looking into. There were several missing persons in and around the state of Georgia that they were attempting to get dental records for and repair. There were tooth extractions that were done during this period, but all in the attempts to find the identity of the person who that skull belonged to. there were attempts to conduct reconstruction. And what further confused it is the anthropologist plots skull dimensions on a scale, and you get a range. Sometimes those ranges overlap. So at some point, they'll tell you that her skull looked like it had been run over, damaged, and she, at some point, the anthropologist thought she could have been stolen male. All this was going on during this period from 1999, April, when they located the skull, June, when they located the extremities. All this is happening during this period, trying to find out who these remains belong to. And ultimately, Melissa doesn't get identified until 2003. And what triggered the identification ultimately is the arrest of Melissa Wolfenbarger's father. You're going to hear that Melissa Wolfenbarger's father essentially pled guilty to committing murder himself, made multiple murders himself. And when he was arrested, it was a notorious publication, it was a notorious arrest. It garnered a lot of attention. You're going to hear that Carl Patton asked the lead detective when he was arrested after he confessed. He asked the detective, told him that his daughter was missing for 3 years and no leads. He asked if he could find his daughter. Well, the detective back to Fulton County Medical Examiner's office, we had this unidentified skull that they found 3 years ago. And with Carl Patton's statement, they obtained the dental records from Melissa Wolfenbarger's dentist, William Grant. Now, pediatric practice in the 80s and 90s, they obtained Melissa's original records, X-ray. Will tell you that she examined the extremities. She'll tell you that she examined the skull and that they appeared
Able to compare the dental impression and x-rays from the skull remains found on Avon Avenue to the dental records she received from Melissa's dentist. I think that's probably, I would probably bring an expert to say that is kind of sus science. And she swapped the mouth of Norma Patton to identify extremities found of June 1995. This is how they were identified. So it wasn't her dad's DNA.
they have evidence 2 months. And she'll tell you that her expert opinion is that Melissa Wolfenbarger was murdered. The circumstances of her lifestyle, how she was living, what's happening to her, the circumstances of her remains, the condition that they were found in, was entirely likely that she was murdered. That's what she'll say. Tina Patton is the sister of Melissa Wolfenbarger that you will hear from at some point today. Melissa told her that Chris was responsible for the bruises on her neck. You'll hear from Norma Patton, Melissa's mother. She was told about the battery in about 98. Melissa told her mother that she wanted to leave this defendant. She told her that he was abusive. And here's Thomas Dixon, Melissa was in. Probably one of the last persons that Melissa saw.
I can't
And also
get shit.
has information he's going to tell you about how abusive this defendant was when Melissa's on out. And you're going to hear from Christina Garrett. Christina Garrett is the daughter of Melissa Wolfenbarger and Christopher Wolfenbarger. And the one thing she'll tell you is that she recalls her mother. And one thing that kind of stood out is she just remembers her mother kind of disappearing one day. And she'll tell you that one of the oddest
Yeah, but
things
I would
that
still
she cannot
try and find it.
reconcile is almost immediately after Melissa just vanished, this defendant essentially just removed all of her stuff out of the house. You can see the picture of mother, belongings, things of that nature. She's gone. While she was growing up, she would constantly ask him, "Where's my mother?" And you expect that you would heard an answer at some point. It's about the explanation where she would tell you that he never answered her question. He never told her how to look for her. He never told her I ever reported this. Nothing. In fact, she would tell you that this defendant would tell her while he was growing up that he knows how to get rid of a lot. He knows how to not get caught. He also told his daughter, and you will hear this from her mouth, that he had a place to go and run if he needed to. Now, Christina Wolfenbarger grew up in basically being cared for by Kathy Wolfenbarger, Christopher Wolfenbarger's biological mother. She lived in the house until she was able to leave when she became an adult. You're going to hear that when she left the house of grandmother and she was able to get out on her own, that's when law enforcement gets that information. Around 2015, 2017, that information about what he told her while she was there. You're going to hear from Dorothy Jones. Now, Dorothy Jones is a resident of that neighborhood at that around the 845 Road area, close to the Action Glass Company where Christopher Wolfenbarger worked, close to the location where Melissa Wolfenbarger's school was located, close to the location where Melissa Wolfenbarger's remains was located. Dorothy Jones knew that location, and essentially what she's going to tell you is she pretty much hung out with Christopher pretty much every day in that period. She remembers. She remembers Melissa. She remembers seeing signs of Melissa being abused. She would tell you that she saw Melissa with the black eye herself, that she had been punched in the eye. She's also going to tell you that she's heard them fighting at that house last break. Probably the most disturbing thing she's going to tell you is that she saw him every day for about a 10-year period. And just one day, Melissa was gone, never saw her again, and Chris was gone. And she says, not only gone,
We don't know
but
what
she kind
day.
of left all the stuff. It's in there. You're going to hear about the signs of trauma. There are going to be some photographs that you'll see solely for the purpose of illustrating the tool marks and the mechanical device that was used to disconnect the limbs of Melissa Wolfenbarger. And most importantly, you'll hear this defendant's own statement. During that 1999 period, he told the officers that he was fired because the owners thought he stole a saw. He admits to borrowing it. He admits to using it to cut the top off his car. They never got the saw back. And you'll hear
The defendant was accused of taking a saw from his job at Action Glass Company in early 1999. I'm sorry, I'm reading this because I can't hear anything this guy's mumbling about. But the body disappeared around Thanksgiving, so he was just keeping the body around for a couple of months.
from the anthropologists, the detectives, the medical examiner, that there are signs that Melissa Wolfenbarger's remains have been solved. You also hear about the day he was arrested, 2024. And it did not go like a typical execution of a warrant for homicide.
Not the extremities.
Because it took quite a bit of time to locate this offender. In fact, they didn't locate him in the residence portion of the house. They located him in the side area, so it was the garage that was situated in the living space. They found
He's not
him
wearing
in
leg
a,
shackles.
something that looks evidence to show that it has an appearance that it was created for the purpose of the house. That's what the evidence is going to show. After about 40 to 50 minutes, they get the dogs, and you just can't hide from the dogs, right? The dogs hit, come on out of there. You see, That's what you're gonna get. When he crawls out of there after an hour, and evidence is gonna show he knew exactly who was at his front door. It was your determination, your decision as to why. I submit to you, it will be clear why. It will be clear. They were there to finally arrest this defendant for the murder of his wife. Arrest this defendant for dismembering his wife. They were there to arrest him and hold him accountable for taking Melissa Wolfenbarger from her mother and sister, most importantly, her children.
But technically, is it illegal to hide from the popo if you claim that, well, I didn't know who was rolling up on me, so I went to my safe room because I was scared there was someone breaking in trying to steal stuff? Is it an admission of guilt that you're hiding? If someone runs around in my house, right now I have every door and window open to try and get some air in. Someone comes in and yells police, and I think, oh, I better hide under the table. Does that make me guilty of a 27-year-old crime? That seems like a far stretch to go through. Maybe he has a street pharmaceutical company and sells medicine in rock form. Or maybe he just don't want to be found by random people who walks into his house. Yeah. Yeah, the judge is Rachel Krause. She was part of the YSL case in some way. I didn't watch this case, so people know way better than me. And this opening is absolutely not engaging at all. And if this is the way they're going to present the case, I'm glad we're doing the Walsh in the afternoon, and then we can speed it up tomorrow and catch up. Didn't want to be arrested for stealing the saw. No, 27 years later, he was like, oh, damn, that saw, man.
Conclusion of this case, the evidence, testimony, the exhibits, you'll be left with one decision. It has to be the truth. And I submit to you, the truth will be guilty. Both counts of the state indicted for the murder of Melissa Wolfenbarger.
Not
Thank
YSL,
you.
Fannie Willis.
Mr. McDermott, does the defense wish to make an opening statement?
Yes, ma'am.
Okay, you may proceed.
We can all agree that Melissa Wolfenbarger did suffer a tragic death. And you haven't yet heard the extent of which she had suffered a tragic life. But the extent of her suffering in life and in death had nothing to do with Christopher Wolfenbarger. The state's story begins correctly. This is a case about a horrifying discovery of human remains that later became identified as Melissa Wolfenbarger's. But the evidence will show you over the next few days that the state's story has gaping holes in it. That the state is going to ask you effectively to imagine in order to connect the dots between those gaping holes. To fill the gaps, if you will. What the state has declined to tell you in this case is far more important than what they have told you. And your job over the next few days is going to be to see those gaps, to refuse to imagine, and to demand proof of all the elements of the crime that is charged beyond a reasonable doubt. You're going to hear evidence, some of it from their own witnesses, that multiple other individuals could have had something to do with Melissa's death, starting with her own parents. You've heard mention already of the Flint River murders. Melissa's father, Carl Patton, committed a string of murders in the late 1970s. He was suspected of those murders for a long time. He was investigated, but they were not prosecuted and proved until 2003, 4 years after Melissa's disappearance and death. You'll be presented with evidence that Norma Patton, his wife, helped him directly commit at least 2 of those murders, to dispose of the bodies, to clean up the crime scenes, and to wrap up the bodies and dispose of them in ways that are somewhat similar to the way Melissa's remains were found. Carl, Melissa's father, died in prison last December. Melissa's father eventually confessed to killing 5 people. Some of those were for personal revenge. Some of those were contract killings for money. And at least 2 of those were murders of his own friends because they knew too much. All of the victims were either close friends or family members. In one case, Carl knew how to stage a crime scene. He turned what was a shooting to look like an accident of a car on train tracks.
Yeah. I object to the defense's content of their opening statement. The statements made by counsel are just simply irrelevant to any issues that are presented during this trial.
I already instantly disliked this guy. First of all, you were so boring that my paint started to get wet again because it said, no, we can't be that. We have to entertain him by drying one more time. And now you are whining over what he says about your opening statement. Shut the F up, sit down, and let him speak.
As previously discussed, they're going to be relevant to third-party guilt and motives.
I'm going to overrule the objection on relevance grounds. I am, however, going to request that you, in line with our earlier discussion pre-trial, limit some of the details unless and until that evidence is presented to the jury.
I will not get into any more granular detail than I have so far.
Thank you.
Satisfactory.
Yes, sir.
Melissa's mother in 2 of those murders was a co-defendant. She confessed to planning 2 cold-blooded murders, cleaning up the blood, bleaching the floor, etc. And the murders from which the name that comes to those murders is the Flint River murders, is because one of those bodies was dumped in the Flint River, the other in the Altamolty River. And the only reason Norma didn't go to prison like Carl did was because she got immunity to testify against him. And she'll be here to testify this week. The evidence will show that there's also a Patton family associate who also had very strong motives to kill Melissa. We're trying to get him prosecuted for allegedly molesting her in the 90s.
What?
And also because his father later turned out, to his knowledge, was one of Carl's victims. And until he learned that, he was a family friend and hung out with the family. And that man's name is Eric Martin Jackson. You'll find out later that at some point Martin learned what Melissa's father had done to his father. And he goes and buys a series of burial plots at a cemetery in 1997, a year before Melissa goes missing, or maybe a year and a half. And he buys them in the very cemetery that Melissa is buried in today. And later, because later he sold those plots to her family. And there are others I'll touch on in just a minute. We expect Norma Patton to come here and testify that she had a loving relationship with Melissa, that Melissa loved her, communicated with her, stayed in touch with her, tried to get away from Christopher's control every chance she could get, so she could come back to Norma's home and see her. But the evidence is going to show that Melissa was actually abused by her mother in her own home for many years and started running away frequently. Her mother locked her in a room all day, every day, from roughly ages 7 to 12. The evidence will show that their home was so foul and dirty that Melissa acquired a foul smell in her clothes and hair that made the other kids at school bully her and tease her. You'll hear evidence from Melissa's next-door neighbor and childhood friend that she will detail the abuse that she endured in that house. Moreover, at some point before Melissa ran away, her sister Tina had a pregnancy in that house, delivered the baby in the house secretly, and tried to dispose of it secretly in a clothes hamper in the house. 13-year-old Melissa discovered that baby's corpse. She eventually told school officials, who later called police, and it was at that point that Melissa began running away from her home regularly. Christopher, in fact, first met Melissa because she ran away from home. And through a mutual friend, they met at that mutual friend's house. Now, Christopher and Melissa eventually got married, and they did so fairly hurriedly. They were both 17 when they got married. They had 2 children, very young, in very close succession. When Melissa was still pregnant with her second child in 1996, she went to Christopher's mother, Kathy Wolfenbarger, who will testify. that Melissa asked her if she would take custody of their children temporarily. And she did. When Melissa got in some legal trouble the next year in Gwinnett County and went on probation for theft, it was after that that they began to, that's when they moved up to Brookline in July of '98. Their children lived with Christopher's mother in Stockbridge and later in Locust Grove, Georgia. When Christopher and Melissa moved up to Brookline in 1998, the children did not go with them. Now, you've heard some talk about an incident that happened in July of 1998 when Melissa took out charges against Christopher. You also heard the state tell you that Melissa came back and dropped the request for that protective order. What they didn't tell you is the very next day, Melissa calls Kathy Wolfenbarger from the Henry County Superior Court and asks her to please come down and sign the papers to make her custody of those children permanent. To make Kathy's custody of Melissa's children permanent. And Melissa permanently relinquishes her parental rights to those children.
On Thursdays, we exercise internal organs because if you want to wreak havoc in Baker's chat, your pancreas better be effing swole. Get pumping that pancreas, Brandon.
One of the reasons Melissa originally gave for giving her children over to Kathy Wolfenbarger, and she tells this to Kathy, and she tells this also to Christopher's sister independently, was that she did not want her parents to have anything to do with her children because they are bad people. After relinquishing her parental rights, Melissa quit working around that time at the Waffle House in East Point with her sister, and for some reason begins randomly working at a Waffle House clear up in Doraville. No one knows why she went up there. According to everyone, no one had any connections up there, friends or family or anything. But she goes up there and starts working. Melissa started spending more and more time in Doraville, days at a time, working double shifts, spending the night at someone's house, and then multiple days, and days turned into weeks, she would be gone from Christopher's house. And it was at that time that she had started seeing Thomas Michael Dixon, the state mentioned a while ago. We'll have a chance to cross-examine him. In October of that year, Melissa got arrested in Gwinnett County for violating her probation, and she spent 30 days in jail until early November. The terms of her probation required her to do community service. This was outstanding for 1997 still. In fact, she was to do community service, she was to take GED classes, and she was to report regularly to her probation officer, and she had not done any of that. So they arrested her, gave her 30 days in jail, and then released her back on the same terms of probation. Within 1 month, she is already violating her probation again. Although she was not rearrested at that time.
Did he say what her arrest was for? Probably drug related.
So at this point in her life, Melissa was spending as much, if not more, time in Doraville as she was at Christopher's house. She only occasionally came back to see Christopher. She had her own job. She had her own money. She had her own circle of friends. She had her own freedom. She had no obligations to her children. And so when in December of 1998, she did not come home for several weeks or months, Christopher could safely assume she had decided to live her own life on her own terms, wherever she decided to live. Moreover, if Christopher had raised a stink about it at the time, Melissa was in violation of her probation. She would have been arrested. Melissa's mother, Norma, is expected to testify variously, as you've already heard, that when she didn't hear from Melissa at Christmas in 1998, that's when she knew something was wrong. Alternatively, however, she will testify that no, it was not until my birthday rolled around. That's when I knew something was wrong. She will tell multiple versions of this story. In one version of the story, well, let me back up. The evidence will show you that in multiple versions of the story, whichever version she tells, she never reports Melissa missing until 2000, January of 2000. If something was wrong in December of 98, something was wrong in February of 99 on her birthday, something is wrong a month later, a month later, a month later, her mother doesn't report it. She doesn't file a missing persons report until 2000. The human remains in this case, as you heard, were found on Avon Avenue. It's an industrial area near the.
I didn't hear what he said. The reason was they could, I think it was some tool markings they alluded to and a new witness. But this is a totally different case than the one I read about. Paula, that's what I always say. This is going to be an interesting case.
West end of Atlanta. The evidence will show that it just so happens Melissa's father, Carl Patton, was familiar with this area. He grew up in a childhood home on Main Street in College Park. It's just a few miles down the road. Further, the evidence will show that Norma and Carl actually went up to Brookline Street right after her birthday in February of 1999. They found Christopher's empty house at that time. They learned from a neighbor that Christopher had moved out sometime between Christmas and New Year's. They also learned that from that neighbor that Christopher worked at Action Glass down on Avon Avenue. So they drove down to Avon Avenue and talked to the people at Action Glass. And they learned that he had been let go there. Again, this is February 1999. Carl and Norma Patton knew where Chris worked and where he lived months before the head was found on Avon Avenue, right beside where he worked. The state is correct that Melissa's mother and sister are going to testify against Christopher. They're going to blame him. They're going to call him a domestic abuser. But there's a lot of context you don't know. Keep in mind, as we've already said, the evidence is going to show that Melissa only met Christopher when she ran away from home. The evidence is also going to show you that Norma Patton has consistently, out of her own mouth, stated that she absolutely hates Christopher. From the very first time she ever saw him, she hated him. She worked and did everything in her power possible to prevent Christopher from seeing Melissa. When he was 16, would not let them date, or tried to prevent them from dating. Tried to prevent Melissa from leaving the house. Tried to prevent them from getting married. She tried to force Melissa onto birth control so that she could not get pregnant. Melissa's older sister joined that opposition to Christopher as well. We'll hear admitted from her own mouth that she did not like Christopher. No one in her family liked Christopher. And that she tried everything she could perpetually to intervene in Christopher and Melissa's marriage to get Melissa to leave Chris. The evidence is going to show that any claims of abuse or bruises on Christopher's part only began to be generated after Melissa started working with Tina at Waffle House. And the evidence of claims of abuse only come from witnesses who came under the influence of Norma and Tina. Christopher and Melissa, as I said, had 2 children, Chrissy and Joey. Chrissy was born in August of 1995, Joey 11 months later. Again, the state is going to present testimony from Norma and Tina, who will say that Melissa would never under any circumstances have abandoned her children. She would not have just left and never kept contact with her children. Impossible. But we already know that, in fact, she did legally abandon them. And the evidence will show that she also practically abandoned them. As I said earlier, when Christopher and Melissa moved up to Brookline Street, the children didn't come with them. They stayed way back in Stockbridge. The children were raised by their grandmother, believing that she was their mother. In September of 1998, when Melissa started leaving for large portions of the time with her work friends and her new lover, Thomas Dixon, she rarely returned to Brookline Street, where Christopher was. She even less hardly ever went down to Stockbridge. You will hear testimony that she rarely visited her children during this time, and that she rarely ever even called them during this time. Whatever Melissa's own personal aspirations might have been in regard to her children, the one thing we do know is the evidence will show that she rarely ever contacted them, and all but forgot about them. You'll hear testimony from Christopher and Melissa's own daughter, who's now grown up, of course. Her name is Christina. Some call her Chrissy. She will testify as a state's witness. She will say that she remembers to the day when her mother disappeared and all the pictures and belongings were moved from the house. Again, the evidence will show that she didn't live in that house. She lived in Stockbridge. The evidence will show you that at that time, Chrissy was every bit of 3 years old. Moreover, Christopher and Melissa's children didn't live in that house, as I said. Chrissy will also tell you that years later, she remembers Christopher making these offhand comments about he knows how to get away with murder, and the key is to hide the body, or to put it under the foundation of a house that's being built, so they'll concrete over it, no one will ever find it. And there are various versions of that story. Christopher's son, Joey, who's also now grown up, will also testify, and he will say he was in the room when such comments were made. And that Christopher was speaking in the context of the boasts that Carl Patton used to make, who was a known girlfriend. We'll have evidence in this trial that early in their relationship, Carl hired Christopher to help him in the roofing business. Chris spent time around Carl and heard him say these things. Even Chrissy will admit that when Christopher made such comments, it was contextual within a discussion and had nothing to do with Melissa whatsoever. Chrissy will also admit that everything she knows about the case, she learned from Norma Patton. Remember what I said at the outset. The state's going to present little points of circumstantial evidence, and they're going to ask you to use your imagination to fill in the gaps. Here are some of the gaps
I don't
I
like
want you to
my
pay attention to.
daughter's boyfriends.
The state will not present any evidence of a cause of death. The state will not present any evidence of a murder weapon. The evidence obviously will show that there were remains that were discovered and that there were marks on the bones. But those wounds are all post-mortem. The state will present you with no evidence of how she died. The state will present no evidence of when she died or where she died. The state will present you with no evidence of where she was dismembered or when or how she was dismembered. They won't present any evidence of how she was transported to this site in the condition that she was. The state will provide claims about a saw that went missing from Christopher's work, allegedly around the time that Christopher was there. No evidence will show, even though the state claims otherwise, that he stole a saw from there, or that he was terminated for that reason. Furthermore, there's no proof that the kind of tool that actually made the marks on these bones was a saw. If so, what kind of saw? We have no evidence of what type of saw it would have been. We've got no evidence that will show that markings are distinctive of this reciprocating saw that was taken versus the circular saw he mentioned when he started his story. Furthermore, your common sense will tell you that there are about a literal million saws in the state of Georgia. Anybody can access a saw. Anyone can access a wide variety of types of saws. You'll hear from investigators from the APD. They will admit that once Melissa's remains were identified, they searched Christopher and Melissa's house on Brookline Street. They searched every inch of the home, inside, outside, every room, basement. They sprayed the entire house with a reactive agent that discovers drops of blood. Not a single drop was found. They took paint samples from every room. Why? Because when Melissa's head was examined, there were chips of paint in her hair. There were synthetic fibers in her hair. And forensic evidence will show that. The fibers were, in fact, found to be consistent with some kind of a bath mat or even a carpet. Very broad category. When Melissa's remains were the paint samples of her remains did not match any of the paint samples from Christopher's house. There was no match of any fiber from Christopher's house. A pubic hair was found on Melissa's remains.
Oh my.
Christopher willingly submitted his pubic hair samples. They didn't match. Head hair samples were found. Christopher submitted head hair samples. The head hair samples didn't match. The medical examiners in this case made DNA analysis of the head almost impossible because one of the medical examiners or anthropologists soaked it in bleach. But the technology still won out in the end. The plastic bags in which the remains have been kept were recently re-examined using the most powerful DNA testing available in modern times, detecting trace amounts of DNA. And sure enough, one of those bags returned a profile that was viable for testing against subjects. It said there were at least 5 human contributors touching this bag. 2 of them were male. Christopher submitted his DNA.
Yes, I did. He didn't shake my hand. And he's dating my daughter.
So the state has some huge gaps it needs to fill. And here's how we anticipate that they're going to try to fill that gap. We expect the state will also call a witness who is somewhat of an expert in the area of domestic violence or abuse. Perhaps you think, well, there's no DNA, there's no fiber evidence, there's no trace evidence in the paint chips. The really important evidence must be in the domestic abuse. But just as with the DNA and the paint chips and the fiber, etc., the expert will offer no support for the prosecution's theory in this case, and here's why. She doesn't know anything about the case. She's never interviewed Chris. She's never read a single police report. She's never even talked to the DAs about the facts of this case. Instead, she's simply going to say that she is a domestic violence expert and tell you signs and symptoms of domestic violence. We anticipate that their testimony on those matters will do nothing to prove that Christopher Wolfenbarger is a cold-blooded murderer. She doesn't know anything about him. She knows nothing. And we will ask you when trial is over to reject that level of fake expert testimony. Another thing, the state's going to offer evidence to say Christopher was the last person to see Melissa alive in December of 1998. You've already heard it. But other evidence is going to show that Melissa's sister Tina actually saw her the following spring.
What?
At that time, Christopher had already long moved out of the area.
What? Come on. Tina saw her half a year later. Okay. Marissa, what is this case? So we're gonna base it on that there's saw marks and he stole a saw. That's why he's guilty. And the mom didn't like him. As I never ever liked anyone who dated any of my daughters. They are not good enough for them. And apparently she made it. What? I read it and it sounded like there was, well, this was a wishy-washy case that they had a new witness and then maybe some forensic tools. The opening statement by the prosecution didn't leave me much hope that they're going to bring on a banger of the case. Hopefully they'll be better, because the opening statements, it was like listening to Cosgrove. What this guy is doing, he's upfront with everything. And I saw someone said, I don't think it's going to be good saying it. Yes, because he's going to say, well, none of this really points to the crime. So I think it's a good idea he's mentioning all the evidence that the state will show them. But I really hope they can get Tina to admit that he saw her. But wouldn't that be after they found the body parts? Because the body parts was found in April, right?
Although Carl Patton was serving 5 life sentences in prison throughout this whole period up until he died last December, that did not stop Norma Patton from firmly expecting he would be paroled at some point. And she began looking into his parole within about 12 years after his life sentence had been served, his first of 4 or 5. And the law technically at the time allowed for someone serving a life sentence to be eligible for parole after 14 years of service in prison. The evidence is going to show you that Norma operated on the belief that the only reason Carl had not been paroled was because his son-in-law, Christopher, had not yet been arrested. She will state explicitly out of her own mouth in a police interview that she believed that as soon as Christopher would be locked up, her husband would be released to come home. And she worked tirelessly for years with the DAs, with the police, and with media campaigns to make sure that happened. Ironically, the evidence will show that the investigators spent hardly any time at all investigating these other potential suspects. No hair samples were taken from them, no DNA samples were taken from them, no pubic hair samples, no searches of their homes, no paint chip samples taken from their houses. No one took DNA samples for this reason from the sister or the accused molester in her home or the friend down the road or anyone else. The evidence will show at most that Melissa somehow died and that someone tried to dispose of parts of her body. The evidence will show that everything beyond that is speculation and imagination. The evidence, as I said, won't show you a cause of death, a weapon, an instrument of death, an incident that led to her death, who dismembered or transported or scattered her remains. There will not be proof beyond a reasonable doubt in this case. There's no DNA, there's no high-powered technology, there's no expert testimony, there's no fiber evidence, no surveillance, no snitches, no co-conspirators, no confession, no eyewitnesses. The evidence will show that the state expects you to fill in all those missing gaps with your imagination. There is no evidence of these charges in this case, and that's why we will ask you at the end of this case to return a verdict of not guilty.
Thank you. Ladies and gentlemen, it's about 12:15, and so we are going to break for lunch. And when we return, we'll begin the evidence presentation portion of the trial. So it is 12:12. We're going to call it 12:15 and break until 1:15 for you to get lunch. Jurors are excused if the deputy will please escort them out of the room.
All right, for the jury.
I don't know what
State.
Not for the
May be seated. Any matters we need to put on the record before we also adjourn for lunch?
Not from state.
Not from the defense.
Okay, we are excused. If y'all, I don't know what the plan is for witness presentation, but do we need to resolve the photographs issue when we return from lunch?
Yes, we did.
Okay, so that's, after I said, I apologize, after I said you're excused, I realized I actually need you guys to come back at 12, I'm sorry, at 1 instead of 1:15, so that we'll just have a few minutes to talk through those issues. Thank you all. We are in recess until 1.
So, this is my attempt on a whiteboard. The center of it is Melissa Wolfenbarger. When I started today, I had an impression that she was a mother of two who were living with her high school sweetheart, who she had a restraining order on. There was some DV going on in the relationship, but she was talking to her family on Thanksgiving. Everything seemed okay, and they never heard from her again. Chris Wolfenbarger, Christopher, he's the defendant. What I knew about him before we started was he was married to her, and he worked near where the body was found, and he hid behind a dryer when the police came looking. I knew Tina Patton, who was the sister, has been an advocate for finding her sister's murderer. Mona, who is not named Mona, but is Norma, was the mother who's also been advocating for someone finding the killer. And Carl Patton is the Flint Grand. He's a serial killer, the Flint River serial killer, killed 5 people. At least that's what he got convicted of. Now, we are 2 hours into it, and we have finished the opening statements. If I am to surmise what I learned from the opening statements, state, Chris is an asshole who beat Melissa, killed her, dismembered her, and chucked her across the street from where he worked because she was wanting to leave him. He disappeared all of a sudden out of the blue from their house, and everything was gone. He stole a saw at work. That's why he's guilty. And he hid from the popo. So clearly admission of guilt. Said in way more words and very slowly. He didn't really talk about Tina Patton. He talked about how Carl was the serial killer and the mom had helped him. If we go by the defense, and remember, these are opening statements, they are not evidence. Melissa had split up from Christopher. She had signed over the rights to her children to Christopher's mother, allegedly to keep them out of the hands of her own family. Her and Christopher weren't in a good place. She apparently had a new guy. She moved out, started working at a Waffle House where her sister also worked, and they were still married, but not at all. She grew up in a house that was so horribly dirty that she started to smell, that her clothes would smell, and she got harassed in school. Apparently, according to the defense, again, all of this is opening statements. None of this has been proven in the court of law. The mother, Norma, locked her up from she was 8 till she was 12 years old in a room in the house. When she was 12 years old, Tina Patton had a baby that she gave birth to in the house and hid the baby in cloth hamper. Is that what you call it? Where you put your dirty clothes. And Melissa was the one who found the baby. She didn't tell anyone to begin with, but started talking to people at the school, which led to Tina getting convicted of, I think, I can't remember what the charge was because I was half sleeping after the state opening. But that led to Tina getting a conviction back in the early 90s. At the same time, according to the defense, nothing has been proven in the court of law. This is when Melissa starts running away from home. While she's running away at a friend's house, she meets Christopher. And they get married. I don't know what just happened. They get married and have 2 kids in quick succession. She gets into some trouble with the law. She's on parole, breaks her parole, spends 30 days in prison, goes back with her boyfriend. Chris doesn't turn her in and reports her missing, again, according to the defense, because she would then have been in violation of her parole, and that's why he didn't do it, so she wouldn't get in trouble and go back to prison. Her body parts are found early 1999, close to where Chris was working. In 2003, Kyle Patton is convicted of killing 5 people, where the mom got immunity from the state to testify against him because because she helped him at least clean up after some of the murders. So he went to prison for life. When he had been in prison for 13 years, Norma, who I misnamed Mona, starts trying to get him out on parole, and apparently claims that she can't get him out because people are still wondering what happened to Melissa. And that's why Chris should be in prison so he could get out on parole. I think that was the cliff notes of what we just watched. I've seen dumber things because I watched the Sarah Boone case. She thought by saying not intentionally, you can't convict her. The evidence, as we heard in opening statement, is nothing. There's no evidence, apparently. There's no DNA, there's no fingerprints, there's no blood at the house, there's no videotape. All of this will be built on circumstantial evidence. And for those of you who says, what is that? Well, circumstantial evidence is the one you have seen from Always Sunny. Where you take all of the circumstantial evidence and then you tie a string to it. And if you can make it stick, you can convict on circumstantial evidence. But this circumstantial evidence is, there's a DV, the mom didn't like Chris. What else is there? Saw marks. Well, they couldn't even say, no, it wasn't saw marks. It was just some marks on the bones, a missing saw at the work. the boyfriend, and I think that was about. I think these are the pieces that the defense believes that the state will try and prove. Is this enough to reach a conviction? I don't know, because we haven't heard how strong the evidence is so far, but it's not a lot to build a case on unless they have. And if the new witness was the neighbor who said, well, I used to see them there all the time and all of a sudden they moved out. Well, they didn't move out till apparently between Christmas and New Year's. And they're going to have the daughter testify that she clearly remembers everything. The daughter, who would have been, 5, 6 years old at the time, clearly remembers exactly the day the mom disappeared. Is that kind of reminds me of the Karen Reed case, where apparently the niece said something very different in her first interview, and then all of a sudden she clearly remembers that Karen Reed said, yeah, I drove into him, I jumped out of the car, I put him in a headlock, I scratched his arm, and Jen is the bestest in the world. I'm paraphrasing. Again, we have no evidence provided so far, and opening statements are not evidence, but if it's anywhere near what the defense, and remember the defense role is to protect their client as best as possible, but if it's anywhere near as flimsy as the defense claims, because that the body is hers and it's close to his place of work, could also just as easy be a cover-up. If you unalived her because, well, her dad, who has unalived people before, was afraid she might spill the beans, could have been a potential suspect. Apparently someone the dad had unalived, had some burial plots that he sold to the family. I don't understand that part of it. This one, I think, is going to be a doozy. And what year from the poll? The year that's in the Chiron. It's going to be an interesting case, but as you might already have noticed, I have put up that we're going to cover the Brian Walls, Miles King, De Los Santos hearing this afternoon to see if anything pops up with the data from Proctor that they still haven't turned over. It sounded like this case is going to be picked up again at 1:15. They have to argue about some photographs. So I don't want to start this for half an hour and then stop and go cover the other one at 2:00. I'm thinking, depending on how long the Walsh hearing will be, that I might come back and speed do the afternoon. It seemed like she liked to go to 5:30, which I don't hope so, because that's 11:30 my time. Or I will start earlier tomorrow and catch up. But this one is interesting. It's very interesting. But I think I'll be covering the Walsh case at 2, and then we'll catch up to the afternoon, either later today or tomorrow. So we can catch up. I do have a bigger whiteboard, but I don't have anywhere to put it. But there's not going to be word crack, because, as I just said, I'm going to end it, pick up the Walsh case, and then potentially this one later. This one is in, I think, a suburb to Atlanta in Georgia. This is crazy. And I don't do deep dives before. I don't, only if it's something that's really interesting and piques my interest, I'll jump in. This one I was sent by Marissa yesterday. I'll look at it, I'll read 5 different articles, then I'll do a summation, and so I just have some of the basic facts. I thought he had killed 3 people, he had killed 5 people. So I again, I didn't know. And any of the articles I read hadn't mentioned anything about the basket baby, hadn't mentioned anything about the mom getting immunity to testify against the dad, hadn't mentioned anything about her being convicted of a crime. So I can't wait for this case to get going. The only thing I'm thinking, how about the witnesses? If they were cops in 1998, they must be as old as Cosgrove right now. In 1998, I was dancing to Britney Spears, having the time of my life, just fresh out of the Navy. I think that was that was 99. I moved to Copenhagen. But I was a young, strapping buck back then. I'm not anymore. I'm 27 years old right now. I'm gray. I have pains in parts of my body I didn't think existed. And I can't sleep for 2 hours without having to go to the toilet. How are these cops going to testify? And how trustworthy will it be? This case that was a cold case for 25 years. This is going to be really interesting. No. This is crazy. I never stream during work hours or sleep hours. I stream all the time. I didn't have mine to first one coming along till 4 years later, 3 years later, 2001, just after 9/11. So when she got a scrapbook of "This happened on your birthday," that wasn't that much of a happy scrapbook. I was just out of the Navy when this happened. How old were you? Just to check how old all of you wonderful people are. 20 to 30 years old, so a little bit older than me. So you're 28 years old. 37%. Less than 20 years old, 30%. 30 to 40, 26 years. Or 26%. Not born yet, 4%. I wanted to put in, I was just a gleam in my dad's eye, but I thought, nope, this is a good Christian channel. We don't mention that. Every kid is born without intercourse because God wills it so. Oh, you are a wee baby. Hey, Kelly DD. Well, I am sweatier than a pig in heat, and I'm going to go wash my face with something cold and get some dinner. I will pick this up again. Let's see how long the Walsh hearing will be this afternoon. We probably can knock some of it out. I have to get up at a decent time tomorrow because I am dog sitting for family because of a funeral. So I do have to do something in my real life tomorrow. But we will try and cover this, and we will cover the entire trial. If anything, we'll catch up over the weekend. Don't you all worry. We will get there. Get out there, get your lunch in, get your dinner in wherever you are in the world, and make sure to come back. I'm going to send you all over to my Brian Walsh stream that I'll start in roughly an hour. So if you're not going to hang out over there and turn on all the bells and whistles, so you might get a notification, you won't till 45 minutes later. Please follow me on the Twitch or the Discord, where I will tell you whenever I go live, so you can come and follow all the craziness we cover on this trial, because I have crazy mods who find crazy cases because I think they are a little cray-cray. And nothing else to do but come back. Baby, come back.
What exhibit are you referring to? I'm going to make this 100, Your Honor. Or 100.
100.
Because it is 100%
100%.
correct.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody has.